He's in custody. We're here this morning on Mr. Allen's motion for reduction of bail. Do we just announce ready, or would you like to have the hearing?
I'm sorry?
We just announce that we're ready to go, or are we ready to?
We're
Okay.
I'm sorry. Yes, ma'am.
All right.
We've announced the case.
Okay.
You announced the case number? 2021 CF 1988. This is a bond, motion for reduction or bond hearing.
Yes, Your Honor. Mr. Allen has been in custody since August 7th of 2021. At this time, I believe his bail is set at $150,000, $50,000 on each count. I believe it's a 3-count indictment. At this time, we're asking, Your Honor, that you consider a bond reduction in addition to that, with special conditions that Mr. Allen be released on a GPS monitor. Mr. Allen is a welder and tree cutter by profession. He doesn't have any prior arrests in relation to the charges that he's being held on today. In fact, I believe the only...
Sorry, say that again?
In fact, the only priors that he have are misdemeanors. Nothing in relation to the charges as alleged today. He also has always appeared in court for his court hearings. We're asking for a bond in the amount of $70,000 with the GPS monitor, and we assert at this time that Mr. Allen is a good candidate for a GPS monitor. And we would ask that Your Honor would consider the conditions as set out by the statute for bail. The alleged victim in this case is actually an undercover police officer. And without delving too much into the case, Mr. Allen was in contact with this alleged officer on an adult site, and in order to actually get on this adult site, both parties need to affirm that they are adults and intend to meet adults. And for that reason, we'd ask, Your Honor, that you would consider reducing his bond at this time.
Judge, we would object to defense's motion for bond reduction. Most significantly, there's been no substantial change in circumstances since the defendant's last motion for bond reduction, September 28th of 2021, when they were reduced from $75,000 per count to $50,000. As Ms. Robinson-Coffey mentioned, he was arrested August 7th as part of Operation Night Owl. He's charged with traveling to meet a minor, using a computer to facilitate or solicit sexual conduct, and unlawful use of a two-way device. He did solicit an undercover officer posing as the mother of a 13-year-old girl for sex with a child, sent images of privates and his face, and eventually traveled to the prearranged location. He also brought candy with him. He does score 45 months in the Department of Corrections. Department of Corrections is state's offer, so we would ask the bonds remain as previously set.
Where are we at with this case? When was
Arrest from when? 2021?
21, and I apologize, I think there was a typo in my motion.
No,
Yes,
that's
Your
all
Honor.
right. No, I'm trying to figure out.
We've got some depots.
My
Okay.
We have depots set for tomorrow, and that should be the last depositions needed. There were a round conducted when the public defender was on the case.
It should be, Your Honor. However, I do want the court to note, in all transparency, I did contact the state. There was another witness that they had listed that indicated that they were going to provide the address. So I inquired about that, and Ms. Barrickman decided that she was going to now withdraw the witness, and inform me of that either late last week or this week. I think it's an imperative witness, so I need to now try to locate this witness. So I don't know how long it's going to take for me to get the address for this witness.
Let's get this case moving. Let's get a trial. I'm going to deny the motion. We need to move this case. It's been a year out. Let's get this case. If you're denying what the charge is, then let's go to trial. That's what we need to do here. Let's get these cases moving.
Thank you.
Court's going to deny the bond. I don't think there's been a change of circumstance, and it is a serious bond, but it's also serious charges. And, you know, I didn't set the bond, but I don't see any change in circumstance that would warrant further reduction.
All right, Your Honor, thank you.
Thank you. The court is standing by. If you need to do anything, a motion as far as
Oh, yeah, as soon as-
to help with depositions, court's standing by to help you with that. That's my job, is to facilitate getting these things moving. So I want I don't want anybody sitting on these cases and these people having to stay in jail. It's not my preference. My preference is to move our cases, but we've got a backlog through no fault of anybody in this room, or anybody else for that matter, because of COVID, and we're working like the dickens to try and move them, which we are. Okay. Thank you, ma'am. David Cornell, Ms. Dudley.
And David Cornell in 22 CF 2224.
So we're here back on this based upon the court's review of the warrant in chambers, correct?
Correct, Your Honor.
We're back here based upon the court's review of this in chambers, and the court has reviewed that. Is there anything further from either counsel? I mean, I'm prepared to, I just wanted to make sure there wasn't
No,
anything
sir.
further that we need to do. The court's going to deny the motion to unseal based upon the sensitive, confidential, informant information that is contained, and also based upon the defense's failure to allege the specific defense that would mandate the unsealing. So that's the basis of my ruling. And if the state, I guess the state needs to get me an order on that? Okay. Okay, anything further we need to do on this case?
No, sir, that's it.
Okay, thank you very much.
The next case I have is Alexander Hanners, 21 CF 616.
The defense announces.
Your Honor, I'm hearing a motion to reinstate or set bond. Mr. Hanners is in jail and on no bond for failure to appear. The failure to appear was back in November 2021. At the time he failed to appear, he was in custody in Alabama. And when he bonded out here, he eventually was arrested on an indictment from an offense date before he was arrested in Florida. And he was held up there until his release, I believe, October 11th of this
So
year.
the failure to appear is because he was incarcerated up in Alabama?
Correct.
Is that, and if we state? Let me try and pull it up. Any help would be? Okay, 2,000 cash professional for count 2, and count 3, $1,000 cash professional ROR. Well, one of these burglary and unoccupied, that's probably not exactly right. Which one is the ROR?
It says count one.
Hold on a second, I'll pull it. The damage to property, criminal mischief, which is count 3, is $1,000. It's true, the burglary unarmed dwelling is an ROR, and the vehicle theft, the grand theft auto is 2,000 cash or professional. State okay with reinstating bond?
Yes, Your Honor, I see no prior failures to.
Okay, court will grant the defense's request to reinstate the bond. So you got the 1,000 cash or professional and 2,000 cash or professional in the ROR.
Yes, sir.
Okay? Anything else on this case?
No, sir, not at this time.
Okay. Thank you very much. Cordell Thomas.
No, we don't skip that. And on the Cordell Thomas, 19 CF 1045. And we're also asking the court to take jurisdiction on the misdemeanor and 22 MM 3059 for a plea. If I may approach.
You may. Thank you.
And Mr. Thomas would admit the violation of probation in 19 CF 1045 and plead no contest as charged in 22 MM 3059. In 19 CF 1045, it would be adjudication of guilt, $100 VOP fee, 24 months in the Department of Corrections with credit for 476 days. Revoke and terminate probation, cost of judgment. That case is run concurrent with 22 MM 3059. And the misdemeanor, be adjudication of guilt, $270 in court costs, $100 PD fee, 90 days in the county jail with credit for time served. No trespassing at the Tom Thumb located at 994 West James Lee Boulevard, Crestview, Florida. Cost of collections, all charges to run concurrent with each other until the felony in 19 CF 1045.
That's the agreement, Judge.
So on the misdemeanor charges, there's 3 counts. So it's 90 days for each of the 3 counts?
90 days is concurrent, so 90 days
No,
total.
no, it's concurrent.
Yes, sir.
But they're for each of the 3 counts.
Correct.
It's just not clear on here. It says they're running concurrent, but it's not clear that the 90 days
sir.
was for each of the 3 counts. Okay. Mr. Thomas, state in agreement? State's in agreement?
Yes, Your Honor.
Mr. Thomas, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see that you have signed a written plea agreement that also contains these terms. Is what your attorney just stated and what's contained in here what your understanding of the plea agreement is?
Yes, sir.
And you're in agreement with that?
Yes, sir.
Have you gone over this with your attorney, make
Yes,
sure you
sir.
had all your legal questions answered?
Yes, sir.
You understand this is the final resolution of your case?
Yes, sir.
And you've talked to her about, you're waiving some valuable legal rights, right to go to a trial, contest it, et cetera?
Yes, sir.
Gone over all that with your attorney?
Yes, sir.
Believe it's in your best interest to do this?
Absolutely.
Very good. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt on all the charges, and the violation of probation, the 1045, will be 24 months. DOC with credit for 476 days. We'll revoke and terminate probation, so when you get out, you're done with it. Cost collection, and then case will run concurrent with the misdemeanor, which is 90 days in the county jail, and all the fees and costs that are contained in the plea agreement. Questions? Thank you. Thank you. Any defense is okay with the score sheet?
Yes, sir.
Okay, thank you. I think that's all you got, Ms. Dudley?
That's all I have, Your Honor. Thank you.
Thank you. Have a nice day. Jared Skiles, Mr. Flaherty.
Morning, Your Honor. Tim Flaherty appearing on behalf of Jared Skiles. The case number is 18 CF 3045. We're before the court today on kind of a status hearing, Judge. We had previously filed a motion for an order to show cause on the failure of two of the state's witnesses to show up for depositions at two prior occasions. Back in early October, the court granted that order to show cause and set the matter for October 19th for them to appear. They did not appear on the 19th, so the court set it for today with the understanding that the state would either have the witnesses or have an explanation as to what the status is, and I do think the state has some information about that.
Good morning, Judge. Zach
Good morning.
Rogers for the state. As of 5:30 yesterday, the sheriff's office in Mobile County was actually able to make contact with these two witnesses in Mobile. We have acquired good email addresses and phone numbers for both of the witnesses, as well as a good physical address for them. It's my understanding, although there was no specificity provided to me, that they were willing to appear. That was the message that was conveyed to me. However, given the short turnaround time, of course, about 12 hours, I was unable to subpoena the witnesses for deposition. Subpoena the witnesses for the hearing today. The way I see it, there are a few options for the court. The last time we were here, Your Honor did express some certainty that if the witnesses were not here today, that you intended to issue an order to take into custody, which is, of course, an option. Alternatively, I would propose that we set this for one more date down the line so that I can, now that I do have a good physical address for these witnesses, subpoena them with a notice of hearing for the next scheduled hearing, Your Honor, at which point the court can have the order to show cause hearing at that time.
And Judge, while we have a client that's charged with first-degree murder that's been incarcerated for over 2 years, and we want to move this case forward, these witnesses are important to both sides. I can only rely on the representations made by Mr. Rogers that they are making a good faith effort to locate these witnesses. So in
Well, it
that
sounds like
spirit,
they finally have made contact. That's a significant, they're not just still trying, they apparently have made contact through a third party, through the Mobile police or whatever.
and certainly in that spirit, Judge, if the court were inclined to grant another hearing, maybe in 2 or 3 weeks, and have them brought here, because I do still think that they need to answer to the court on that order to show cause that the court granted.
Is this the first time they're aware of this? So they were aware of something previously and
Well, to be
didn't
clear-
show?
To be clear, it's my understanding that they were served with subpoenas for deposition previously. As to the order to take into custody, I believe this is likely the first time they've been made aware of it. To the extent the court wishes me to do so, I can certainly convey to them your intention to issue an order to take into custody if they fail to appear.
Why don't we come back on December 1st? But you can inform them, and the clerk's minutes should, in case somebody else is here, which is likely, sitting in this chair. Because I'm going to be in the South End on the 1st. So if you will make the clerk's minutes reflect that the court intends, if I was here, the court would intend to issue a pickup order if they don't appear.
Understood, Your Honor.
Okay? So you have the right to get them here and whatnot. So we're going to do whatever we can to do that. That's appropriate and what's quote-unquote fair.
Yes, Your Honor.
So,
Thank you, Judge.
okay, thank you very much.
What was the time on that, Judge?
That'd be 9 a.m., sir. Just a regular morning. It's a miscellaneous docket.
Yes, Your Honor, thank you. We'll see you soon.
Judge, that is all I have, if I may be excused.
Sam Collingwood, Mr. Stewart, is he here? Yes, sir.
John, can I pass my case for a moment?
Sure. Okay, there's a couple that, without attorneys. Kenneth Finney. So, and there are a couple of other individuals right behind this, so listen up to what I'm about ready to say, because it'll apply to the next two cases after this, Mr. Morgan and Mr. Price. These are violations of probation that have been filed against you. You have not been appointed an attorney, so the first thing I would say to you is that you have a right to an attorney. If you cannot afford one, one will be provided. So
Yes,
you
sir.
wish to have an attorney appointed?
Not at this time, sir.
Your Honor, we did work out an agreement.
Okay.
It would be for an adjudication of guilt, revoke and terminate his current probation, reinstate with new probation of 12 months, cost of supervision waived, $100 cost of prosecution, early termination upon payment of court costs.
Very good.
That's all he had left to.
Sure. So let me just ask you a few questions, make sure you understand what's going on here.
Yes, sir.
So would you raise your right hand, Mr. Finney? Let me swear
Yes,
you
sir.
in. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So I see you've signed a plea and sentencing agreement. It's
Yes, sir.
actually a violation of probation, community control plea agreement that contains the terms of your plea agreement. I just want to make sure you understand, you don't have an attorney here. You have a right to an attorney.
Yes, sir.
You're voluntarily giving up that right for today's hearing based upon this plea agreement that you've entered into.
Yes, sir.
Do you feel like you understand this plea agreement sufficiently from a legal sense to
Yes, sir.
understand? I mean, there's an adjudication of guilt. There'll be revoke and terminate probation, so you'll have an extended probation period.
Yes,
And there's
sir.
some costs, so you're not going to, at this point, there's no jail time. So,
No,
I mean,
sir.
obviously, that's an important element, and it makes me more likely to accept your plea because you're not subjecting yourself to jail time at this point.
Yes, sir.
Although, if you mess up in the future, probably
Yes, sir.
you're closer to it today than you were yesterday, but if you can get straight on this probation, you can finish it up and move on beyond that. So you do understand, though, you have a right to go to a trial on this violation of probation. You're giving up that right, and this will be a final adjudication of your violation of probation.
Yes,
Which is
sir.
kind of like a new charge. It's not kind of, it is.
Yes, sir.
Okay, do you understand all that?
Yes, sir.
Okay, and you believe it's in your best interest to do that?
Yes, sir.
Okay.
Yeah.
Based upon your testimony, the court will accept the plea agreement. There'll be an adjudication of guilt, revoke and terminate probation. You'll have a new term, 12 months of probation. Cost of supervision will be waived, and there'll be some additional cost of prosecution. You will have the opportunity for early termination. You can pay up your court costs and et cetera. Okay?
Yes, sir.
Okay, any questions?
No, sir.
You'll check in with probation there. They'll get you moving in the right direction.
All right, thank you, sir.
Thank you. Have a nice day. Ethel Morgan.
Judge, this is 19 CF 1093.
You just come up to the podium, ma'am.
Judge, Ms. Morgan's here on a violation of probation. It's my understanding that she has 5 more classes to do at Bridgeway, is that right? Yes, 6. 6 classes, okay. Judge, she doesn't have an attorney, but I've spoken with her probation officer here in court today, and she's indicated if we maybe can reset this for December 1st, that would allow the defendant to complete her classes at Bridgeway, and the ultimate goal would be if she does successfully complete, the state would be asking the court to dismiss and revoke and terminate her probation.
Okay. So the court will grant that. The court, let's go ahead and continue this till December 1st. So come back December 1st at 9 a.m., same time. If, for whatever reason, I just want you to know, I'm not going to appoint you an attorney right now. Because it'll be completed without the need for one. But if you come back for whatever reason, it's not concluded, before we take any action that would kind of be negative against you, you would have the right to an attorney. So I just want you to know that that's kind of sitting back there. We'll come back, hopefully, the state is basically accommodating you, trying to help you get through this. You've made progress, and we want you to be successful. If for some reason you're not, you would have a right to an attorney. We're not going to do that today. But today, all we're doing is continuing this hearing until December 1st at 9 a.m.
Okay.
Okay? Okay, stay in touch with your probation officer in the interim, okay?
Okay.
Thank you. Daniel Price.
22 CF 437. Judge, this is Mr. Price. He does not have an attorney. It looks like he is here on a violation today for failure to pay restitution. If Madam Clerk could confirm how much money's owed, this could be a situation where we could just extend it, give the defendant the opportunity to get the restitution paid up, and then dismiss and revoke and terminate.
Well, has any been paid? Have you paid any of your restitution?
Sir, I paid court costs and that was it.
Okay. So it looks like the 1,600 are, so you understand a little bit what's going on. I'm not your attorney and I'm not giving you advice, but I just want to make sure you understand what the state just said. State just said basically, you haven't paid this restitution. We're coming to the end of the probation, so they're going to violate you on your probation because you didn't pay this within the term of your probation. Do you have,
I'm currently not working. I'm in a rehab program, and so I'm there for
What
the
is this-
time being.
so when are you going to be out and be able to be working?
About 8 or 9 months. It's a long program.
Okay,
It's the Haven House.
Okay. I would ask that the defendant bring documentation of that.
I have a representative from the Haven House with me.
Okay. I can go speak with that person, Judge, and then we can kind of regroup
Okay.
and go from there because, the restitution hasn't been paid, so we need to figure out where to go from there if we just need to reset it or whatnot. But I'll go speak to your representative.
I have a question for you, Judge. Am I labeled as a felon right now?
Was there an adjudication of guilt?
It was a withhold of adjudication on this case.
The reason I ask is because I hold a natural gas and propane license, and once I get my life straightened out, I want to continue back with my work. And if I have a felony, I can't have my own business.
Yeah.
Sure. It was withhold of adjudication, so you were not a convicted felon on this case for the court
Thank you.
at this time. But if you don't get your restitution paid, then you're going to be before the court for a violation of probation, and it could become an
One of the
adjudication.
things they'll do is they'll ask the court to do an adjudication of guilt. So let's just pass over this. We're going to just hang with it, let the state talk with the folk. We'll come back here this morning, okay?
right.
Just hang with us.
Thank you.
Okay. Okay, Alexis Baggett. Flowers, good morning.
Morning, Judge.
Good morning.
Good morning, Your Honor. This is Alexis Josephine Baggett, Jennifer Flowers, for the record on her behalf. We're here on 21 CF 868. This is a VOP. She's prepared to enter an admission today. We have an agreed-upon sentence with the state. Just going to have her sign really quickly. And Your Honor, the The terms of the agreement would be that she would enter an admission to the violation of probation in 21 CF 868. She would be adjudicated guilty. Probation would be revoked and terminated. She'll serve 6 months in the Okaloosa County Jail with credit for time served, a $100 VOP cost of prosecution, $150 cost of defense, and the money should be paid within 180 days of her release from jail, and then, if not paid, sent to collections. May I approach with the...
Okay. State in agreement?
Yes, Your Honor.
And
There's a score
the
sheet.
defense stipulates to a score sheet.
Okay, thank you. Ms. Baggett, would you please raise your right hand, ma'am? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard the defense, your defense counsel explain the terms of your plea agreement. I see you've signed a written plea agreement that lists those out. Is that your understanding of what the plea agreement is?
Yes, sir.
And you are in agreement with that? You understand that by entering this, you have the right to contest it and to go to a hearing on it and whatnot. You're waiving those valuable rights. This will be a final adjudication of this VOP. Yes? And you believe it's in your best interest to enter into this plea agreement? Okay. Any questions regarding this? You had all your legal questions answered?
Sir.
Okay. Very good. Based upon that, the court will accept your admission. There'll be an adjudication of guilt, be revoke and terminate probation. So no more probation when you come out. It'll be 6 months in the county jail. One thing I don't think your attorney stated, but is very important, I know is always the case, is that you will get credit for all time served. Okay? Cost of prosecution and the other costs have to be paid within 180 days of your getting out of jail, or it'll go to collections. Okay? Any questions? Okay. Thank you very much. And that's right. You already said about the sentence. Thank you. Sorry. Robert Caporaletti.
If I could just have 1 second
Sure.
to discuss. One more second. All right, Your Honor, this is Robert Louis Caporaletti. And actually, could we, can I speak to the state just really quickly? Sorry.
Sure.
It'll take
If
1 second.
if you need to have some further consultation, we can hold this and come back to it, too.
No, Your Honor, I just wanted to clarify with the state that she was okay with it. Your Honor, we're here today on 2020 CF 449 is the VOP that's on the docket. I would also like to address, and I believe the state is okay with addressing his two outstanding misdemeanors that are not on the docket. They are contained in this plea agreement, and we've worked out a global resolution.
Just make sure and identify those,
Yes.
the misdemeanor charges so that the clerk can make sure
Yes.
and make it a part of
The
record.
misdemeanors are case number 22 MM3719. That's 1 count of petty theft. And 22 MM3681. That's 1 count of resisting an officer without violence. And then, like I said, the VOP is 20 CF 449. 1 count of possession of controlled substance, that's the felony, and 1 count of possession of drug paraphernalia. Mr. Caporaletti would like to withdraw his denial in the VOP and enter an admission. For an agreement with the state would be to adjudicate him guilty, serve 4 months in the Okaloosa County Jail with credit for time served, revoke and terminate probation, a $100 VOP cost of prosecution, a $150 cost of defense, money to be paid within 180 days of release and then to collections. And 22 MM 3719, he would be adjudicated guilty of the misdemeanor petty theft, given credit for time served, concurrent with 20 CF 449. I believe that's $270 in court costs. $100 cost of defense. That money also to be paid within 180 days of his release, then to collections. And 22 MM 3681, he would be adjudicated guilty of 1 count of misdemeanor resisting officer without violence, given credit for time served, concurrent with 20 CF 449 and 22 MM 3719, so all concurrent. Another $270 court costs, $100 cost of defense, money to be paid within 180 days of release, then to collections. And, Your Honor,
Would also be $50 cost of prosecution on each misdemeanor.
okay. I'll write that on. Said a $50 cost of prosecution, okay.
Hey, Mr., how do you pronounce your last name? Caparoletti?
Yes, sir.
Okay, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? You heard your attorney state the terms of your plea agreement. Is that your understanding of the plea agreement? All right, just want to make sure you're in agreement with all that.
Yes.
Okay? And have you had it, would you bring me that?
Yes, I'm just going
Does
to.
he have to sign it?
Can
Okay,
you
go
sign
ahead.
it really quick? Sorry. Just right there at the top. I know it's hard with the cuffs on. And may I approach?
Thank you. That's all right. Thank you. Okay, so I'm also looking at a plea and sentencing agreement that I saw that you just signed. Have you gone over this agreement, this plea agreement with your attorney? Make sure you had all your legal questions answered? Okay, because you're giving up some valuable legal rights by entering into this plea. You're agreeing to the 4 months, but you're waiving the right to go to a trial on your misdemeanor charges and this VOP. You can contest all these, and I just want to make sure you do it, you understand what you're doing, and that you're doing it with agreement.
Yes, sir, I do.
Okay? I mean, you've had all your legal questions answered. You believe this is in your best interest to enter into this plea agreement?
Yes, sir.
You understand that by entering into it, it's a final adjudication of all these 3 cases. You're finished with this.
Yes, sir.
There'll be an adjudication of guilt on the primary charge, the VOP. There'll be 4 months in at Okaloosa County Jail. You will get credit for time served. That's important. There's a number of fees and costs that were outlined by your attorney and are contained in this as well. You'll have 180 days to pay those when you get out. Then after that, it goes to collections. Okay? Do you have any other questions about what we're doing? Okay. Very good. And the defense is okay with the score sheet?
Yes, Your Honor.
Okay. Very good. Thank you very much. Hey, Taya Hinton.
Your Honor, this is Taya Hinton in 22 CF 1982, Jennifer Flowers on her behalf. We're also here on 22 CF 1983. Your Honor, I think she previously entered a plea of not guilty and was put on today for just a status. I've not had a chance to meet with Ms. Hinton yet, so we're asking to continue, maybe just put it on the next pretrial in December so that I can meet with her, get discovery.
We'll continue to December 1, 9 a.m.
Is that a miscellaneous date?
It is.
Okay, these are new charges.
These are new charges?
Yeah, these are two new
How
charges.
do we have
so-
them on our miscellaneous day?
I'm not,
Okay, so we need to do it on our pretrial.
Your Honor, if I may.
Sure.
There was, so I had her case originally, and
Okay.
then she was supposed to have a bond hearing. And
Today?
yes, well, she was supposed to have it when I had the case, and we had to withdraw after I filed it, and so I think this was set to see if Ms. Flowers wanted to have her bond hearing, I believe is what happened.
and I'm not ready to do that
Right.
today. I am not prepared, I'm not sure if that's what I would
Right.
advise doing at this
Right.
time.
Okay. So do you want to just,
Let's
are
keep-
we already set for the next pretrial? Let's ask that question. If we are, then we, okay. Okay, so the next pretrial is December 28th.
Okay, if we could put her on for there, I'll go meet with her, and then if I do feel that I need to do a bond motion, I'll just ask to put it on a miscellaneous docket before then.
Very good.
Thank you. I'm gonna come see you soon.
Jeffrey Miller.
Jeffrey Miller is present and approaching, Your Honor. Jennifer Flowers on his behalf in 21 CF 1120. This is a VOP. Mr. Miller is prepared to enter an admission to the violation of probation with the understanding he would be adjudicated guilty. His probation would be reinstated to the original term date of February 2023. He would have a $100 VOP cost of prosecution, a $150 cost of defense, and he would have to complete all the original requirements, reinstate all the original requirements. It's my understanding he only has like 3 classes left of his substance abuse.
That's the agreement, Judge.
And there is no score sheet. This was a misdemeanor plea.
Thank you. Mr. Miller, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. So there's a violation of probation you're going to admit. There'll be an adjudication of guilt, and you'll just reinstate the probation, give you a chance to complete that with the original requirements. Apparently, you've made a substantial amount of progress. We just want you to finish those up so you can be successful at that. Get this behind you, okay? There are a few fees and costs that you have to pay as well. They always try and get a hand in your pocket for all these fees and costs, and it has to be done during the terms of the probation. Is all that what you understand it to be?
Yes, sir.
And you understand you're waiving the right to go to a trial, and you're waiving some rights. This is the final adjudication of this violation of probation?
Yes, sir.
And you've had all your legal questions answered by your attorney?
Yes, sir, I have.
Okay. Very good. I think that'll do it. Thank you very much.
All
And
right.
just meet with your probation officer, make sure you're situated on that. You need fingerprints?
Your Honor, to prevent us from turning around and filing another VOP on Mr. Miller, we're trying to be proactive here.
Okay.
The violation was failing to do treatment and failing to pay monies.
My understanding, I got a violation of probation included with new charges, both positive UAs and everything.
And there's a failure, and there's monies to be paid. His termination date is set for February of next year, a couple of months.
Right.
By the time we get him back to the office, we're fixing to file another violation report saying he didn't pay the money, unless we put the money to collections at this point, or at the end of supervision.
Are you okay with?
State's fine with that, Judge.
We'll do, what's being suggested is to go, as you try and pay as much as you can. If you come to the end of your probation, you haven't finished paying, it'll go to collections. So you won't be violated for not making your payments, but you're still going to be responsible for them, but it'll go to a judgment if you can't get them paid by the end of your probation. Talk to him, make sure he's comfortable with that.
Thank you, Judge. I was just
Thank
trying
you,
to.
Mr. Barry. No, I appreciate you doing that.
I'll talk to him also.
Okay. I think he understands, and I think it's in his best interest to agree to that today.
Okay, very good. Thank you very much.
And I think that's all I have on the
I
docket.
think you do.
Or-
I think
I have
that's
one
all.
more, or?
No, I think that's
Okay,
all
I
you
think
got.
that's
No. Unless, the next one is Chesser. Who is the attorney? It's listed as Miss Rivers. I don't think that's correct. Listed as the defense attorney.
And Your Honor, if I may, I actually
That
looked
yours?
this up in anticipation. No, I just looked it up in anticipation. I believe it's a pro se motion to early term.
Okay.
If I'm reading it correct, would you like the paperwork, Your Honor?
Uh,
Yeah, I printed
Sure.
it just in case
That'd
the
be
court
great.
was curious.
Thank you. So, but Ms. Flowers, yeah, I just wanted to make sure you weren't somehow
Right,
appointed
right.
in the,
There was one, William Talbot, I think, that was supposed to be on his we filed a not guilty plea for his new charges. The VOP was still on for the afternoon, but my secretary just said that was taken care of. I wasn't planning
is
to come
that
back.
for the plea? The plea?
I'm asking to basically continue the VOP to track
Right,
with the new
I
law.
just want to make sure it's not on our, I don't have it on our.
Okay, all right, then we're good.
Great, thank you.
Who are we talking about? Sorry.
I'm sorry. Talbot, hold on just a second, Mr.
So
Flowers.
they do want the VOPs. Yes, please.
Yeah, okay, thank you. You want to double back on the
Yes,
pro
Daniel
se?
Price.
Hold on a second, let me,
I think he's doing Chesser. I don't know what he's saying. He wanted to look at that.
Chesser is the pro se judge.
no,
We
no,
have
I was going to double back on Mr. Price, who
Okay.
you were talking
Okay,
about.
good.
And then we'll do Chesser,
Okay.
Daniel Price.
yeah.
This is 22 CF 437. And Judge, I've spoken with the representative from the Haven House. We're going to give this defendant 3 months continuance in order for him to make some payments towards the restitution. Or even 2 months. Some payments need to be made, despite the fact that he's in rehab. He does have some assets he could sell to pay off restitution for this victim. So the restitution, that's
Okay,
number
so we,
one.
so for today, we need to just continue this or come back in 3 months?
Let's set it for 2 months,
Okay?
and we can see if there's been any progress made.
Your Honor, I'd like to say something. I'm currently going through a divorce, and all my assets and everything are tied up in that. So I literally have nothing. That I can't put up anything. I have everything that I have with Mrs. Price is tied up right now through a divorce. So, I mean,
He was put on probation in April. He was able to pay court costs. This victim is owed $16.50.
So what do you propose to do? You owe the victim $1,600.
I would like
What do you
to,
want to do? We're trying to work with you. What
yes,
you
sir.
got?
Thank you. I would like to finish my program with the Haven House and then get back on my feet and pay the guy his money that he's owed. I'm not trying to not pay it. I wasn't healthy. Bottom line.
The Haven House judge is not a condition of his probation. So while I appreciate the fact that the defendant's trying to get his life in line, he didn't enter the Haven House until September 27th of this year. He's been on probation since April. So the state does have a little problem with that, but I would like to give him the opportunity, give him 2 months. We'll see where he is, see if any payments have been made.
Who knows? Your divorce might be finalized. There might be some agreement that you can sell some. We're looking for some good faith movement toward it. That's what we're trying to, we're not trying to be unreasonable. I really do appreciate you trying to get your life together. We want you to be successful. It's not that. But, you know, there's another side to this, and that's people that are on the receiving end of this. You know, a lot of times day after day, we bring people here that are the defendants. A lot of times the victims, they don't ever get hurt. So we'll come back in a couple months, and if you can, we'd ask you to try and make some progress on it in the next couple months in some way. Maybe you can sell something or resolve your dispute and just see where we're at, okay?
Thank you, Judge.
Okay, so let's get a date for you. December 29th, okay?
You know,
You can go see him, but
I
they're.
want to
go
talk to
ahead.
him. Do I have to?
No, they need to, yeah, he needs to talk to you.
Showed me like 17 people.
Okay. Mr. Stewart, you want to do your cases?
Yes, Your Honor. Good morning, Your Honor. May it please the court, Brad Stewart, present.
Before you start that,
Yes, Your Honor.
is Mr. Chesser here? Tommy Joe Chesser? Let me deal with this. This is a pro se, Mr.
Yes, Your Honor.
Morning, Your Honor.
Good morning. Hold on a second. Okay. So, has the state had an opportunity to, what I'm reviewing is the September 20th. It's essentially a letter to actually another judge, but it's being considered, it's before the court basically as a pro se filing or motion of some sort. And I was wondering if the state has reviewed this. This is the one where you asked for the credit for the 562.
Yes, sir.
They say we're not giving credit for, et cetera.
Yes, Judge. I can speak to the CAC case, which is the 19 CF 46, the failure to register as a sexual predator. I know Mr. Cheshire was asking for the gain time. In review of the benchmark record, it does look like the 562 days of jail credit were awarded to the defendant on 2/18. And he received credit for that time when he served the 12-1 Department of Corrections time he was originally given. However, as for his probationary period, it appears from benchmark he was placed on 3 years of probation to follow that. And there was also a civil lien that was assessed in a Walton County case that was transferred over as a concurrent condition of probation in this case. Given he is on probation for failure to register as a sexual predator, has had 2 technical violations for alarm guns, and isn't scheduled to terminate until June of 2023, we would object to early termination, and I don't believe at this point that the gain time would apply to the probationary period. It would just apply to the 12-1 he did on the front end of the 19 CF 46.
Okay. Does he have a right to an attorney in this? Does he need to get an attorney appointed?
Your Honor, I had asked him to contact Ms. Flowers, being that she represents the organization that I was at, for her to assist him with this.
That was your prior attorney.
I called her, she never did call me back. See, I stayed incarcerated in Department of Corrections from the time I was sentenced here on February the 13th until June when I got put on probation.
So, did you hear what she said, what the state just said?
Yeah.
She said the 562, which is the days you're being given credit for, was, that gain time, no, it was credit, was given to you during the 12-1 sentence. But it doesn't apply to the probation.
But I was in prison for the whole period of a year and a day until June of 20.
Why don't we do this? You need to get your attorney to go through this. I'm not,
And if
I
necessary.
know it's her, I know she's at the state. They're with She used to work in the regional conflict office. She doesn't work over there anymore.
Yes.
If necessary, Your Honor, would you reappoint RCC to help him with this
Sure.
matter?
Okay, and also, Your Honor, my restitution was already put in collection, so it was put in collection in Walton County. I have a paper right here, my probation officer gave me yesterday.
Why don't we, so what we're going to do is I'm going to appoint the ORCC. You've got their number, right? And-
Jennifer Flowers, right?
Yes. And let's come back and let them look at it and can argue a little more on your behalf. So we'll come back on December 1st. Okay.
Thank you, Your Honor.
Get in touch with her in the meantime. Okay, thanks. Okay, Mr. Stewart.
Thank you, Your Honor. May it please the court, Brad Stewart present. Your Honor, my first client on the docket is Mr. Collingwood. Judge, that is case number 21 CF 3098. Mr. Collingwood is present and approaching, Judge. I do have a fully executed plea and sentencing agreement in this regard. Your Honor, may I approach?
You may. Thank you.
Your Honor, this time Mr. Collingwood is prepared to tender a plea of no contest with the understanding that he is pleading to the lesser-included offense of misdemeanor criminal mischief in count 5. The plea agreement calls for 12 months of standard reporting probation, 515, I'm sorry, it's going to be 275, Judge, in misdemeanor costs.
Now, which one are you talking about? Okay. Tell me again the terms.
Yes, Your Honor. It'll be an adjudication of guilt on the lesser-included offense of count 5, misdemeanor criminal mischief. Be 12 months of standard reporting probation, 275.
Hold on. I'm not tracking you on your... Help me out here.
Yes, Your Honor. If the court will look on page 1,
Yeah, I'm looking. on
section 1, number 5,
there. Right.
it is the lesser-included offense,
Come
misdemeanor
here.
criminal mischief.
No, I'm saying that, but the actual... And do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. So 4 of the counts are being dismissed, and the last one is a lesser included. And basically, the core of this is 12 months probation. Sounds like a pretty good deal. Obviously, you're aware of the no contact rules. These are one-sided contact rules. Even if they try and reach you, you're the one who's going to get in trouble if you have any type of contact. So stay away from them, even if you have, it means you receding from them trying to contact you. You understand that?
Yes, sir.
Obviously, you've got no violent contact with Haley Head. That, as you know, allows you to have contact, but just does not allow you to have violent contact. You can't have violent contact anyway, but it's kind of a exclamation point that you got to be careful with that, because anything happens, any violence, you're the one who's going to be getting in trouble quickly, okay? So you also have the court costs, et cetera. So I see you've signed the plea and sentencing agreement as well as the verbal that you just heard. I just want to make sure that you've had all your legal questions answered. If you can go ahead and talk to your attorney. Sure.
Submit that modification. We're good, Your Honor.
Okay. So just want to make sure you had all your legal questions answered. You got your final one answered here just while we were standing here. Got all your legal questions answered. You're waiving the right to go to a trial, so you are waiving some valuable legal rights. I can understand why you are. You got a good plea agreement, but I just want to make sure you are clear about this. You've had all your questions answered.
Yes, sir.
You're entering this freely and voluntarily.
Yes, sir.
And the defense is okay with the score sheet?
Yes, Your Honor.
Okay. State's okay with this? They're in agreement?
Yes, Your Honor.
Okay, very good. The court will accept the plea agreement, 12 months of probation, the court costs, and the no contacts that were stated and are stated in this, as well as the potential for early termination. Okay? Good luck.
Can I pay court costs today?
Yeah. They always accept your money.
Not today.
Not today?
Sure.
Really?
Boy, I gotta.
They got to process it. You got to come back.
Tomorrow.
They won't take your money right now.
Where did I go?
Right here, have
He's going to finish printing. Your Honor, my next client is Mr. Cox. If I could pass that for a moment, Judge. This, we had a issue with the Keaton program. I just need to inform Mr. Cox of that.
James Lee?
Mr. Lee is an inmate, I know. Your Honor, for the record, Brad Stewart, on behalf of Mr. James Lee. Judge, this involves three case numbers. This is 22 CF 466, 467, and 22 CF 2639. Your Honor, if I may pause for a moment while Mr. Lee signs the previously reviewed plea and sentencing agreement.
You may.
So we were only on. Yeah. So everything, as we discussed, 602 there, fines and court costs and the other ones. Okay. Good. Your Honor, I do have a executed plea and sentencing agreement along with the corresponding score sheet. May I approach?
You're okay with the score sheet?
Yes, Your Honor, no additions. Mr. Lee is prepared to tender a plea of no contest, Judge. All cases, all counts. The substance of the agreement, Judge, is it's going to be a withhold of adjudication. It'll be 2 years community control. That'll be concurrent between all felony cases, all felony counts, with 6 months Okaloosa County Jail as a special condition thereof. Judge, it's fines and court costs as announced therein with the additional special conditions as announced therein. We're requesting that the court merge and dismiss the traffic offenses. As it relates to the misdemeanors, those will be resolved with time served. I'm also requesting the court waive the cost of prosecution based on the amount of special conditions.
Plus 100 hours, did you say the 100 hours of community service, forfeiting the firearm, don't possess the firearm? Did you go through all that?
Yes, Your Honor. She shall not return to 609 McClellan Street. He's going to be subjected to random urinalysis, drug evaluation with follow-up treatment, and a mental health evaluation with follow-up treatment as well.
So except for the traffic cases that are credit for time served, all the additional counts each of them will be 2 years of community control with the special condition of 6 months in the county jail?
All the felony counts, yes, Your Honor.
Each of those will be, okay. You say it says concurrent, but doesn't say, okay. So, Mr. Lee, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of your plea agreement that are also contained in the written plea agreement that you have signed.
Yes, sir.
You want to make sure you've gone over this and you're clear that you're in agreement with this plea agreement because you're giving up some valuable rights, the right to go to trial, to contest all these and to fight them.
Yes,
This is
sir.
the final, you understand this is the final resolution of this case.
Yes, sir.
Have you had all of your legal questions answered? Do you understand this plea agreement? Gone
Yes, sir.
over it with your attorney?
Yes, sir.
Okay. So obviously, the core of this is the 2 years of community control with 6 months in the county jail with credit for time served as a special condition. A lot of fees and costs that he went over with you, including obviously the important requirements that you not own or possess a firearm during the probation, can't return to 609 McClellan Street, the other terms and conditions, mental health evaluation, no drugs and alcohol. Do you understand all that?
Yes, sir.
The misdemeanor charges, the traffic charges are all credit for time served. Very good. Any questions regarding this?
Cost of supervision, Your Honor.
Cost of supervision is waived.
Thank you.
Any questions?
I have a question.
Sure.
On the traffic citations, it's not my general practice to resolve traffic citations in criminal court.
Right?
You have discretion to do that. You mentioned the traffic citations and misdemeanors would be time served. Does
Correct.
that mean he would be convicted? Because I know the defendant was requesting that they be merged and dismissed regarding the citations. So,
And just to clarify, Judge, the misdemeanor counts on the cases announced were being resolved with time served. We are requesting that the traffic citations that came along with these cases are merged and dismissed as part of the res gesta, the substantive offenses alleged therein.
I don't understand what you just said.
The traffic
You wanna
offenses.
explain that to me?
The traffic offenses are consumed by the big boy cases.
Well, but consumed, but you're saying dismissed. That's what she's
I'm-
objecting to, that she doesn't want them to be dismissed. The fact that they're subsumed in it, I don't know that that's legally the correct term, but I understand what you're trying to say.
Consumed.
I think.
I'm requesting that the court do so. If the court's uncomfortable doing so, we'll set it for hearing before Judge Ward. It's not an issue.
Okay, let's do that. Why don't you make, just because the state's not in agreement. So it's not up to me. I'm not opposed to it, but
No, I understand, Judge. It just- it's-
state's uncomfortable with it, so we'll do that. So why don't you just change this here?
Stated as a request, Judge. I'll be happy to mark it up.
Okay. Are you still okay with all this, even though we're not dismissing the traffic? You'll have to deal with that separately?
Yes, sir.
You sure? You hesitated. Talk to your lawyer if you have any questions here. You okay with that? That's a change. We just changed your plea agreement. My whole question, and I have two things when I'm talking to you that I'm trying to do. One, make sure you understand what you're doing and that you're in agreement with it. We changed what you just did, and I want to make sure you're in agreement. That's all I'm asking. You good with this?
Substantive change, it was a request on those traffic offenses, citations.
All right. Yes, sir.
You good?
Yes, sir.
Okay, thank you. Christopher Merricks.
Judge, can I pass Mr. Merricks for a moment?
Perez, Mark Perez.
Your Honor, Mr. Perez is present. I was a bit too aggressive in setting Mr. Perez for today. We do need a bit more time to work on Mr. Perez's case. If I can continue that matter, I anticipate bringing it in for a landing.
This was brought on this case from pretrial, right?
Yes, sir.
Do you want to go to the next pretrial?
That'll be fine, Judge. What is that date?
And we can always move it up, Your Honor, if we get a resolution before that.
12/27.
Very good.
Roman Portugal.
Yes, Your Honor. My next client is Mr. Portugal. Your Honor, this is 21 CF 2403. Judge, at this time procedurally...
There's two others, aren't there?
Yes, Judge, it's two TR cases, which I think we just established we're probably not going to resolve, so...
Okay, well, we still need to announce because they're on my
Very good.
docket here.
21 TR 11097, 21 TR 11098, for the record, Your Honor.
Okay.
Judge, as it relates to Mr. Portugal, we are going to enter a plea at this time as it relates to 21 CF 2403. We are going to set sentencing on the December 1st court date, I believe, is the next court date. Madam Clerk, could you verify? Very good. If we could set it for that morning?
For sentencing?
Yes, Your Honor.
Is this a plea to the court?
No, Judge, it is agreed upon plea.
But we're holding the sentencing until then?
Correct.
Or do we need to do the colloquy now as far as, or we just want to continue the plea until then? You want to just continue the whole case and then we'll,
I'd rather go ahead and do the plea, Judge, now and then set off the sentencing if the court doesn't mind.
Okay. That's fine. You want to go ahead and announce?
Yes, Judge, at this time, Mr.
You got to announce what we're agreeing to. Even though I'm not sentencing today, we still have to announce the agreement of what I am going to sentence on December 1st so that he can agree to it.
Your Honor, at this time, Mr. Portugal is prepared to tender a plea of no contest to counts 1 and 2 as alleged, with the understanding that he will be adjudicated guilty, placed on 5 years reporting probation. He will have a special condition of 4 months in Okaloosa County Jail, credit all time served, be followed by the inpatient treatment to complete at Keaton Program. There will be appropriate fines and court costs, the amount of $4,000 fine. I believe it's going to be $486 in court costs. 100 hours community service work, no drugs or alcohol. There's a 10-year driver's license revocation. Would request the court have no objection to a business purposes license if otherwise eligible. There's a 90-day impound of the vehicle, Judge, 2-year interlock. Must attend and complete the multi-offender DUI course as well. That encompasses the agreement, Judge, that will be passed to December the 1st for sentencing.
Okay, very good.
That is the agreement.
Very good. Thank you.
Does the court want to do it?
I need to look at that because I need to ask him questions about it.
Very good. Your Honor, if I may pause while Mr. Portugal signs the previously reviewed sentencing agreement. May I approach, Your Honor?
You may. Thank you. How do you pronounce your last name, sir?
Portugal.
Portugal?
Yeah, just
Mr. Portugal, would you raise your right hand, sir? Do you swear or affirm that the information we're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So I've just been handed a plea and sentencing agreement, and your attorney explained what, you can put your hand down, explained what the agreement was. I want to make sure that you understand this agreement and that you're okay with it, okay?
Yeah, yes.
So, you heard your attorney state that, and I see you've signed the back of this plea and sentencing agreement. Did you go over this agreement with your attorney?
Yes.
And you understand that by entering into this plea agreement, this will be a final resolution of your case, except we're not going to sentence, and I understand why, until next December. Not December, this coming December 1st.
Yes.
Okay, so you're agreeing to it today, to this agreement, but we're actually going to sentence you on December 1st. Do you understand that?
Yes.
And what you're agreeing to here today is that there would be an adjudication of guilt, 5 years of probation, and as a special condition of that, there would be 4 months in the county jail.
Yes.
With credit for time served, followed by inpatient treatment at Keaton. Okay, that's obviously probably the most important thing. There's also some other things. There's very large fine, community service hours, and 2-year interlock, 90-day vehicle impound, multi-offender DUI school, all those things. Have you gone over all that with your attorney? Make sure you understand what all this means?
Yes.
And you're comfortable with it?
Yes.
Okay, 'cause we want you to be successful at this. And there's a lot of pieces to this, obviously. You understand that?
Yes.
So have you had all your legal questions answered by your attorney?
Yes.
And you understand this will be a final resolution?
Yes.
Other than the sentencing? It'll be in December. Okay. Based upon your testimony, the court will accept your plea agreement and will sentence you on December 1st pursuant to this plea and sentencing agreement. Okay?
Okay.
Any questions?
No, sir.
Okay, thank you very much.
You're welcome.
Do I give this to the clerk? I guess she needs this.
Yes, sir. Judge, I believe it may be prudent if we go ahead and fingerprint
Okay.
at this time. He'll have to be fingerprinted for the.
And then the other two cases, the traffic cases, just we're not taking any action today.
No, no, Your Honor.
Okay, very good. David Wheelock?
Yes, Your Honor, my next client is Mr. David Wheelock. Judge, this is 22 CF 951. Mr. Wheelock is approaching.
I've got this down here as a hearing, and I wasn't quite clear what we were doing here today.
Yes, Your Honor. Procedurally, Mr. Wheelock was taken off of the docket for purposes of evaluation in Veterans Court. We set this here today for early plea.
Okay.
Your Honor, I do have a executed plea and sentencing agreement. May I approach?
You may. Thank you.
At this time, Mr. Wheelock is prepared to tender plea in the contest with you. Standing on count one, will be a withhold of adjudication, $615 in court costs payable within 120 days. Counts 2 and 3 will be an adjudication, time served.
Very good. Mr. Wheelock, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of the plea agreement, and I see that it's in writing and that you've signed the back page of it.
Yes, sir.
So, you gone over this with your attorney and make sure you understand? This
Yes.
will be a final adjudication of your case. You're waiving the right to go to a trial. This is a final resolution. Do you understand that?
Yes, sir.
You had all your legal questions answered of your attorney.
Yes, sir.
And everybody's okay with the score sheet, Mr.?
Yes, Your Honor.
Okay. So based upon that testimony, the court will accept your plea as to count 1, the possession of a controlled substance, adjudication withheld, fees and costs payable in 120 days. Counts 2 and 3, adjudication of guilt, credit for time served. And after the 120 days payable, within 120 days, would it go to collections?
Yes, Your Honor.
Put that in there. Just so we
Well,
can
actually, it would be assessed, I guess, as a civil lien technically.
We can put that in there, whatever.
We'll just put-
Sure. Okay. Anything further for Mr. Wheelock?
No, Your Honor.
Okay, thank you, sir. You got a couple coming back, we want to,
I do,
take
Your
on, we're going to do them now, or?
If I may pause for a moment and recall those matters in a moment, Your Honor, for me.
Okay, why don't we go ahead and take our morning break? That'll be a good break, and then we'll move to the remainder. We'll take about a 10-minute break.
All rise.
seated. We'll put it on the record. Yeah, I just need to take it. I'll put it on the record. Thank you. Mr. Stewart?
May it please the court, Your Honor, Brad Stewart, back on record. My first client is Mr. Cox.
Go ahead and announce the cases.
Your Honor, as Mr. Cox approaches, this is case numbers 20 CF 1796, 21 CF 564, and 22 CF 261. Your Honor, at this time, Mr. Cox is prepared to admit the VOPs and enter a plea of no contest in 22 CF 261. I do have a fully executed plea and sentencing agreement, Your Honor, with this corresponding score sheet. May I approach?
You may. Thank you.
The subject of the agreement calls for a modification on the VOPs, and the substantive new law violation will be a withhold, be placed on 18 months community control with a special condition to attend and complete Keaton inpatient program and aftercare. There's VOP fee, $615, and court costs on the new law violation. Judge, will be a mental health evaluation with follow-up treatment. May convert the last 6 months to standard reporting probation upon probation's recommendation. There'll be time served on all misdemeanor counts. Judge, I'm going to ask the court to waive cost of supervision based on the inpatient treatment.
State?
That's correct, Your Honor.
Okay, Mr. Cox, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
I just need to ask you some questions, make sure you understand what you're doing with your plea and that it's free and voluntary. So you heard your attorney state the terms of your plea agreement, and I've been reviewing your written plea agreement that I see you have signed as well. Have you gone over this plea and sentencing agreement with your attorney, made sure you understand all the legal ramifications of this?
Yes, sir.
You understand that by entering this plea, it's a final adjudication of these cases? And
Yes.
you're waiving the right to go to final hearings on them and contest these things? You
Yes.
believe it's in your best interest to do that?
Yes, sir.
And you've had all your legal questions answered from your attorney?
Yes, sir.
Very good. Based upon that, the court will accept your plea, admit the VOPs, and plea no contest in 22 CF 261. The core of this, you'll modify existing probation in the VOP cases. There'll be withhold, 18 months of community control with the special condition to complete Keaton, and fees and costs as well. The mental health evaluation, is that something that would be a part of the Keaton program? Is that something that needs to be done before he goes to Keaton? After he goes to Keaton? I'm just trying to...
Your Honor, the state would ask for after, the goal being that he get into Keaton first.
Okay.
That would be my understanding, Your Honor.
Okay.
However, it just dawned on me that if he has health issues, he has been screened and they agreed to take him.
I just believe that under the circumstances, a mental health evaluation would be appropriate.
Under the circumstances as they're saying it, he will not receive any mental health treatment that I'm aware of until he gets out of Keaton.
Correct.
They apparently have evaluated him for Keaton and feel that that's appropriate. So which is a little contradictory to have a mental health evaluation, but I don't have a problem with kind of just doing a double check when he gets out, but
But we will, I can promise you that upon him getting out of Keaton, we will send him to our mental health evaluation if he does not have one before he gets to us.
Okay. Okay. So the answer to my question is that it'll be after the Keaton. So you're already squared away to go into Keaton. That's what's important.
Correct.
And it would be done in conjunction with the aftercare from the Keaton program, Judge.
Okay. That's fine. Thank you. Appreciate you
Thank you, Probation.
clarifying that. So, any other questions, sir? Okay. Good luck.
Judge, would the court declare waiving cost of supervision based on?
Yes, absolutely. And you're okay with the score sheet?
Yes, Your Honor.
Okay, very good. Thank you. Merrick's, I think is your last case, Mr.
Yes, Your Honor. My last client is Mr. Christopher Merricks. Mr. Merricks is present and approaching. Judge, this is 21 CF 3173. Judge, Mr. Merricks at this time is going to withdraw his previously entered plea of not guilty, tender plea of no contest to the lesser included misdemeanor offense of DWLSR. Judge, we're entering a plea on this. We will be coming back on the 12/27 pretrial docket for sentencing. And the substance of the agreement would be an adjudication, 10 days Okaloosa County Jail, credit time served. It'll be $300 in court costs payable within 90 days. That'll be deferred to 12/27. It is a misdemeanor, Judge.
So the sentencing will be on 12/27, is that what you said? Okay.
We're getting messed up here. So. 300 is what it was. It's payable within 90 days after sentencing. Sir? County, may I approach?
You may. Thank you. Okay, Mr. Merricks, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So as you heard your attorney state, I'm going to ask you some questions about this plea agreement. And want to make sure that you understand the plea agreement is free and voluntary. But you're actually going to be sentenced on 12/27. You're going to agree to it today. Okay, we're just basically putting off your sentencing.
Piece of time, yes, sir.
And I kind of probably understand why. So, you heard your attorney state the terms of the plea agreement: adjudication of guilt, 10 days in the county jail with credit for time served, and then fees and costs. That's basically the core of your plea and sentencing agreement. Is that your understanding of what the agreement is? I see you've signed the plea and sentencing agreement as well. Have you gone over this? Just make sure you understand what all this means to you legally from your attorney?
Yes, sir.
You know, there's an adjudication of guilt. You understand you're waiving the right to go to a trial. You're agreeing to this plea.
To get it dropped down to a misdemeanor?
That's correct.
Yes, sir. Yes,
That's
sir.
right. And I didn't say that, but it's on the thing, so.
Yes, sir.
And for Madam Clerks, for the minutes, the misdemeanor statute is 322.34, subsection 2B2.
Okay. So you're pleading to a misdemeanor. Is that a lesser included?
Yes, Your Honor.
It is, Your Honor.
Okay. A misdemeanor driving on a suspended. Okay. So do you have any further questions about this plea agreement?
That's all I have, sir.
Okay. Very good. And you're entering into this freely and voluntarily?
Yes, sir.
Okay. Very good. Court will accept your plea here today, and we'll come back on 12/27 at 9 a.m. For the sentencing. Okay?
Sir.
Okay. Thank you very much.
Thank you, too.
think that's all you got there, Mr. Stewart. You have a good day.
Your Honor, that's all I have. Thank you, Your Honor. May I be excused?
Thank you. We just need to put one thing on the record. Lena Creech, that was continued because she couldn't be transported in time from the state hospital. This was,
She made it to the state hospital? That's the reason why she was on the docket, was a control to see if they had finally sent her to the state hospital. Oh. So she's still here. Okay.
I was told that she was being transported from Chattahoochee and that we didn't get the order in time. What other Creech?
There's more than one Creech that
On
has
what docket?
committed.
I only have one on this morning's docket. Is there one that, we have one later
Stephen
today?
Keach is also on this morning, Creech, Stephen Creech.
Who's on this morning?
He is.
He is 27, yeah.
Okay, Stephen, so which one are we talking about here today?
Okay.
Are we talking about Lena?
Both, yes.
This morning, we're talking about Lena is the one who, is at an appointment? Okay,
She's represented by RCC.
okay.
She's still here.
And she's waiting to go to Florida State Hospital whenever they come pick her up,
Okay.
is what I'm understanding.
Okay,
So do we want to put her on for another control?
yes.
uh,
That's what the
Yes.
clerk was saying, we need to get another hearing.
Into the month?
December 1st. Okay, thank you. I'm sorry for the confusion. You want to, and what about Stephen Creech? Is that the one that the order wasn't signed?
Yes, Your Honor.
Okay, so we can go ahead and deal with that.
Sure.
We just need to schedule it in time for him to
Um,
be transported.
Yes. Do we know if the order has been signed now or no?
I think the order was signed, but it
Okay,
just wasn't
it just wasn't
signed
in
in
time.
time
So we
to,
could try 11/7? You
We
think?
can try 11/7, that's fine. If you think that's enough time, Your Honor, do you believe it's?
I don't
I don't
know,
know how long they
y'all
take.
tell me.
11:10?
We need, why are we doing it that quick? What am we?
It doesn't matter, Your Honor. I mean, he
12/1
has,
is fine,
I'm,
right?
I'm okay. What?
I mean, 12/1 is fine, Your Honor. I mean, he is, yeah.
Okay,
He has two cases and one of them's like has prison time offer, so it's okay.
okay, 12-1.
Okay.
Okay, so we'll continue with the regular morning docket. Ashlyn Banks.
Casey Etheridge for Ashland Banks, and we're here in 2021 CF 225. May I have one moment, Your Honor? Okay, that's fine. Got it? Let me move it.
Crazy, the sun right here.
I know.
Sorry.
All right. Casey Average for Ashland Banks, he would like to admit to the allegations in the affidavit and accept the state's offer. It would be for adjudication of guilt, revoke and terminate probation, 120 days in county jail with credit for all time served, $100 cost of prosecution, $150 in public defender fees, all fees, fines, and court costs reduced to judgment.
Mr. Banks, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Just want to make sure you understand what you're pleading to and that you're entering it freely and voluntarily.
Sure.
You may. And the score sheet okay?
Yes, Your Honor.
State in agreement?
Yes, Your Honor.
Okay. So, Mr. Banks, you heard your attorney state the terms of the plea agreement. I see that same, those terms are contained in your written plea agreement that you've signed. Is that your understanding what the plea agreement is, and you are in agreement with that?
Yes, sir.
And you understand that by entering this plea agreement, you're waiving the right to go to trial, and you're
Yes, sir.
waiving basically several of your important legal rights.
Yes, sir.
Do you believe that's in your best interest to do so?
Terminate probation, yes, sir. It is.
So, and that's exactly what will happen. This will terminate probation, so have to serve the 120 days with credit for time served. But you don't have to get any probation when you come out. You'll be done.
That is absolutely.
Is that what
fine
you
with
want to
me.
do?
Yes, sir.
Okay. You've had all your legal questions answered from your attorney?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt, revoke and terminate probation, 120 days in the county jail with credit for time served, plus the fees and costs that'll be reduced to judgment. Okay? Any questions? Thank you. Blackshear. Jerry Blackshear.
Casey Etheridge for Jerry Blackshear, Your Honor, and we're here for a motion to reduce bond.
You may proceed.
Okay. Your Honor, Mr. Blackshear's bond is $212,000 cash or professional, and he is unable to afford his bond. May I take testimony from Mr. Blackshear?
Sure. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
All right, Mr. Blackshear, are you able to afford the bond at $212,000?
No, ma'am.
Okay. And if you were out of custody right now, would you be working?
Yes, ma'am.
Okay, and where would you be working?
Software,
Okay,
software,
okay. And where's that located?
off Airport Road. It's a cable tie, like
And where would you be living?
living School Avenue.
Okay. Okay. Is there anything else that you would like for the court to take into consideration when deciding whether to reduce your bond today?
Charges have been dropped. The aggravated stalking and two-way communication.
I don't have any further questions, Your Honor.
I don't have any questions, Your Honor.
Okay, very good.
Your Honor, we would just ask if the court would lower the amount of the bond. It's so excessive that he can't afford the amount, and we would just ask that the court do a lower amount, a reasonable bond for him to be able to bond out and handle the charges.
Hold on just a second before you make arguments.
You might have to remind me. Your Honor.
State's argument.
Yes, Your Honor. Mr. Blackshear is charged with trafficking in methamphetamines. He is charged with more than 28 grams but less than 200 grams. He's also charged with trafficking in fentanyl, which is, that in and of itself is a very serious charge, considering all the problems that we're having today in society based on the nature of that substance. So these are two very serious charges, along with other possession charges. And his criminal history is also very serious. Your Honor, he has priors which include home invasion with a firearm. And he has others that also, let's see, also has another serious prior felony, which is shooting into an occupied vehicle. He has resisting without, battery, grand theft, possession, sell, manufacture, and deliver. This appears to be a trend for him. Fleeing and eluding. The state believes that although the bonds are high, that they are appropriate based on his prior criminal history and based on the current charges.
Anything further?
No, nothing further, Your Honor.
These are very high bonds, but the court will have to agree with the state. These are very serious charges, and it's two issues when you're dealing with bonds. One is whether or not it's a reasonable amount, whether somebody can meet that, and it's also safety to the general public. And in this case, there's a lot of history here, and you're going to have to resolve these cases. So, the court's going to deny. What's his next? Is he on for the next pretrial?
1228.
1228 for the next pretrial.
Yeah, correct. Just send somebody. Yes.
Rosero.
And Your Honor, I believe it's Mr. Bracero. I'm not sure, Your Honor, this is before my being here. But they are still at Florida State Hospital. We received a report late yesterday afternoon saying that they are still competent to proceed. They didn't arrive at Florida State Hospital until August of 2022, and so they're going to need more time for competency training.
He's on his way from the Florida State Hospital? Oh, he's on his way to the Florida State.
Right.
Yes, Your Honor, you previously found him
Right.
incompetent and committed him back on
This was just a status. We were trying to get him, and now he's on his way,
Correct.
so.
6-month status to see how he was doing.
Okay.
Yeah. So if
6
we could
months?
set it 6 months out, that would be.
Madam Clerk? March 30th, 9 a.m.
Thank you, Your Honor.
Very good. Foster Caps?
Casey Etheridge for Foster Caps, and we're here in 2020 CF 3092. If I may have one moment. Mr. Capps would like to admit to the allegations in the affidavit and accept the state's offer. It would be for adjudication of guilt, revoke and terminate probation, 11 months, 29 days in county jail with credit for all time served, $100 cost of prosecution, $150 in public defender fees, all fees, fines, and court costs reduced to judgment.
That's correct, Your Honor, and this would be a legitimate, uncoerced plea. It will be a slight downward departure.
Defense okay with the score sheet?
Yes, Your Honor.
Mr. Capps, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard you can put your hand down. You heard your attorney state the terms of your plea agreement.
Yes, sir.
I see you've just signed that plea agreement. Have you gone over it with your attorney?
Yes,
to Make
sir.
sure you understand kind of the legal ramifications? Because by entering this admission, you are waiving a number of legal rights. The main one is that you're waiving the right to go to a trial, to contest these and to fight these things. Do you believe it's in your best interest?
Yes, sir.
To enter into this plea agreement
Yes,
here
sir.
today? And you believe you've gotten all your legal questions answered from your attorney?
Yes, sir.
Satisfied with the legal work?
Yes, sir.
Legal advice from your attorney? Okay. And did I ask you about the score sheet, counsel? You okay with
Yes, Your Honor, you did. Yeah, we have no
Very
objections.
good. Based upon that testimony, Mr. Capps, the court will accept your plea agreement. There'll be an adjudication of guilt, revoke and terminate probation. When you get out, you don't have to worry about probation anymore. 11 months, 29 days in the county jail. Obviously, and importantly for you, you will get credit for all time served. Fees and costs and fines and court costs all reduced to judgment. Okay? Any
Yes, sir.
questions?
No, sir.
Okay, thank you. Castleberry.
Casey Casey Etheridge for Barry Castleberry. We're here in 2021 CF 1308. If I may have one moment, Your Honor. However you need to move it. Your Honor, Mr. Castleberry would like to admit to the allegations in the affidavit and accept the state's offer. It would be for adjudication withheld, revoke and terminate probation, 12 months of community control, cost supervision waived, same terms and conditions, substance abuse evaluation, any recommended treatment, and he must sign up for this evaluation within 90 days of release, $100 cost of prosecution, and $150 in public defender fees.
State.
Mr. Barry, do you
That's
see a
correct,
reason
Your
that
Honor.
would be an issue, that he signed up within 90 days? Okay.
We'll ensure that we instruct Barry to get down there and sign up for Bridgeway.
Very good. Mr. Castleberry, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? You heard your attorney state the terms of the plea agreement. Is that, you can put your hand down. Is that your understanding of what the plea agreement is? Are you in agreement with it? I see you've signed the plea and sentencing agreement, contains the same thing. Just want to make sure you're accepting the plea agreement, kind of look at you eye to eye, make sure you're comfortable with it. Yes? You understand that by entering this plea agreement, you're waiving the right to go to a trial, and this will be a final adjudication of this violation. Do you understand that? If you have any questions about what I'm asking you, you can talk to your attorney if you have a question about it, okay? I want to make sure that you understand what we're doing here. Mr. Barry?
Can I approach?
You may.
Counsel?
Counsel? That we're talking here, that you understand what this agreement is, okay? So you got any questions, just raise your hand, I'll let you talk to your attorney, okay? We're not trying, no, nobody's trying to trick you. We want you to understand. It's important that you understand what we're doing, because we want you to be successful. We're terminating probation, but you're getting 12 months of community control. Do you know what community control is? House arrest. That's another word for it.
Yes.
A lot of supervision. Are you willing to do that? And you also, importantly, you've got to sign up as soon as possible, within 90 days for that substance abuse evaluation.
Yes, sir.
You willing to do that? Follow any recommendations? Well, the most important thing of this whole process is you got to stay in good contact with your probation officer. You know? Call, check in when you're supposed to. You can always pick up the phone. That's why that's their job. Okay? But you got to make sure and do that in order to be, so you can be successful. I don't want you, because I hate to say this, but you know, you got probation, community control. What's the next step? You don't do this community control. Then likely the state's going to be recommending jail time. So work this thing, okay? You understand? But I want to make sure you understand it here. So all the fees and costs will go to collections after 90 days. No. Fees and costs that have to be paid during the terms of the community control. Okay? You understand that? Okay. Very good. Any questions? Okay. And the defense okay with the score sheet?
Yes, Your Honor, no objection.
Good luck. Sindel Chris.
Casey Etheridge for Sindel Chris, and we're here in 2021 CF 688. May I have one moment, Your Honor? She would like to enter a no contest plea and accept the state's offer. It would be for adjudication of guilt, revoke and terminate probation, 90 days in county jail with credit for all time served, $100 cost of prosecution, $150 in public defender fees, and she'd have 180 days to pay or be reduced to judgment.
Ms. Chris, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Just want to make sure you understand what you're agreeing to and that it's free and voluntary, okay? You heard your attorney state the terms of your plea agreement. I saw you just signed the plea and sentencing agreement. Have you gone over that with your attorney? Made sure you had all your legal questions answered about it?
Yes, sir.
You understand that by entering this plea here today, you're waiving the right to go to a final hearing. This is a final adjudication of this violation of probation. Do you understand that?
Yes, sir.
And you've had all your legal questions answered? And your plea here today is being entered into freely and voluntarily? Nobody twisted your arm or coerced you to get you to enter into this plea?
Yes, sir.
Okay.
And this is
Very
a
good.
misdemeanor, Your Honor, so there is no score sheet. I'll just
Okay,
make sure the
thank you.
court's aware.
Very good. Based upon your testimony, the court will adjudicate, there'll be an adjudication of guilt, revoke and terminate probation. You don't have to worry about probation when you get out. 90 days in the county jail, you'll get credit for time served. Got to pay the fees and court costs, 180 days after you get out of jail, or it'll go to collections. Question?
No, sir.
Okay, thank you very much. Fiducia. David Fiducia. If I pronounce that right?
Yes, Your Honor, I believe so. Casey Etheridge for David Fiducio. We're here in 2021 CF 667 and 2021 CF 1433. May I have 1 second, Your Honor?
Yeah, I was out this morning. Yeah, the case number. That's different. Yeah, he on it.
May I have Ms. Glisson approach, Your Honor?
You may.
Your Honor, we would ask to continue this to the 12/29 docket.
Very good. Court will continue to 12, I think it's 12/28. Did you say 12/29? 12/28. The pretrial? No. Pretrial or the miscellaneous?
There's a miscellaneous on 12.
It's a miscellaneous on 12/29.
Correct.
Yep.
12/29, sorry.
Oh, yeah.
Lewis Frazier.
We're looking at everything. Okay. Casey Etheridge for Lewis Frazier. We're here on 2021 CF 689 and 2022 CF 2657. We're asking to bring that case in. I don't think it's on this docket, Your Honor. It's a new law violation, and we're asking to resolve both cases today.
What's that case number? Do you have that?
Yeah, it's 2022 CF 2657.
Okay. And what are the charges there?
Okay. Possession of a controlled substance. And Mr. Frazier would like to admit to the allegations in the affidavit and enter a no contest plea to the 2022 CF 2657, accept the state's offer for, on 2021 CF 689, the violation of probation. It would be adjudication of guilt, revoke and terminate probation, 6 months of community control, same terms and conditions, an additional $100 cost of prosecution, and an additional $150 in public defender fees. And on 2022 CF 2657, it would be for adjudication of guilt, 6 months of community control concurrent with 2021 CF 689, $515 in court costs, $100 cost of prosecution, $150 in public defender fees, no possession or consumption of alcohol or controlled substances without a prescription.
State in agreement?
Yes, Your Honor.
The defense okay with the score sheet?
Yes, Your Honor.
Mr. Frazier, I just need to ask you a few questions. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. You heard your attorney state the terms of the plea agreement. Just want to make sure you're in agreement and you understand what you're doing here.
Yes, sir.
Okay? So obviously, the core of this is the 6 months of community control. You understand? I like house arrest. That's a better description.
Yes, sir.
Are you willing to do that? A lot of supervision. Don't want you to mess up. You got to be willing to step up and do this.
Yes, sir.
Committed to it? If not,
Yeah.
you know what the next step is after community control?
Yes, sir.
What's the next step?
Prison.
Yeah. And that's not where, I mean, may not always seem that way, but that ain't where we want, it's not where we want you. There are enough folks over there,
I know.
okay? So we need you to be committed to follow up with this. 6 months, it's kind of high intensity, but it's not forever. You willing to do that?
Yes, sir.
All the fees and costs will be assessed during that time frame as well, okay? Have you had all your legal questions answered about what this means? You're waiving the right to go to a trial.
Yes, sir.
It's a final adjudication. You understand all that? Have you satisfied with your legal representation?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt on both the charges. 6 months of community control, concurrent, so they're both running together, not on top of one another, and all the fees and costs as well. No alcohol or controlled substance without a prescription. Okay? Follow up. Do that right. Okay, thank you.
And Your Honor, a little housekeeping on Mr. Frazier.
Yes, sir.
We request the supervision fees to be waived.
Yes, sir.
And additionally, with 6 months community control, I assume he's going to owe the old money, the new money. We're fixing to be back on VOP on that. What about monies to collections at term, if no other violations?
Yes.
State has no objection.
No objection.
Thank you.
Thank you.
Anything else, Mr. Berry?
No, sir. Thank you, though, for that.
Thank you. Graham, Elizabeth Graham.
Casey Etheridge for Elizabeth Graham, Your Honor. I didn't know she was present. I called her name earlier. If we could just pass her for a few minutes, Your Honor.
Okay. Isaac Guerra, if I'm pronouncing that correctly.
I believe it's Guerrera, Casey Etheridge for Mr. Guerrera. We're here in 2022 CF 1096. His presence was waived. We actually did a stipulated waiver of appearance with the state. This is for a restitution hearing. He lives in Texas, and so we agreed to waive his appearance.
Okay. So,
And then, okay, so, and we're agreeing to an amount of $250 in restitution, Your Honor.
okay. State's in agreement?
Yes, Your Honor.
Very good. If you'd get me an order, that'd be great.
Yes.
Thank you. Jason Kuntz?
Casey Etheridge for Jason Koontz, and Your Honor, we're here for a motion to reduce bond. This is in 22 CF 2066 and 22 CF 2067. And Your Honor, Mr. Koontz's bond right now is $100,000 cash or professional. In each case, I believe, let me make sure, yes. And he's asking, he has no prior record, Your Honor, and we'd just be asking for the court to reduce his bond to something he can afford. Would you like to say anything? Okay, okay. Nothing further from defense, Your Honor.
Hey?
Judge, as Ms. Etheridge stated, bonds are $50,000 per count. He's before the court in 2 cases. He's been charged in each case with 1 count of using a computer to facilitate or solicit sexual conduct of a minor, and 1 count of using a two-way device, for a total of 4 counts over the 2 cases. In 1 case, the defendant was chatting with what he thought was a 14-year-old female on Meet Me and Snapchat and solicited her for sexual activity. He also misrepresented his age in that case. In the other, he was chatting with what he believed was a 13-year-old female on Meet Me and Kick and solicited her for sexual activity. Score sheet reflects 91.6 points, or 47 months in the Department of Corrections with a maximum of 20 years. Especially concerning to the state is that the defendant was soliciting 2 different undercover underage personas during this operation. The defendant is from Birmingham and he travels for work by his admissions in the chats. He has been extradited from Alabama on these charges. His prior history includes a misdemeanor FTA, and he has no ties to this community. So due to the facts of the case, the risk the defendant poses to the community, and the state's flight risk concerns, we'd ask the bonds to remain as set.
And Your
Anything else,
Honor,
counsel?
and Mr. Koontz did find out about the warrants and did turn himself in, and that's when he was extradited from Birmingham, I believe it was, Birmingham.
What is the defense requesting?
One moment, Your Honor. Your Honor, we would ask if the court would do $25,000 on each count. I think that's still a reasonable amount, and I believe that they may be able to work something out for that, Your Honor. He does have a job, Your Honor, and so that's, but that is in Alabama. I know that the court, has concerns that he may not come back, but he did turn himself in to come down here, so. And Your Honor, he does have 2
Participate in pretrial services, even if the court?
I do believe pretrial has already been imposed as conditions for the current bond with GPS, sex offense conditions, et cetera. I don't know how well they'd be able to supervise him from Alabama.
I'm sorry. Were these, you said
The conditions that were announced at first appearances included GPS,
Right. But
sex
my
offense
point is,
conditions.
can he even abide by those if he's up in Alabama?
Are
How
you
does that
asking
work?
about the GPS, Your Honor? I mean, he can definitely be on the GPS, because I have somebody right now in Iowa that's on a GPS from down here. So I know that
I'm just
he can
wondering,
do
you know,
that.
if they're,
And his parents are here. He wanted me to tell you that they're here at the hearing.
so what is it currently, 50? 50 per count?
That's correct, for a total of 200,000.
Or to reduce it to 25 per count with the pretrial services requirements. No unsupervised contact with minors, can't be where minors congregate, GPS. No use of the internet. You understand all that?
And that would include the sex offense conditions imposed at first appearances as well.
That's what I was reviewing
Okay.
right now. Yes, absolutely.
And basic cell phone only, please.
I'm sorry?
And basic cell phone only.
Correct.
Thank you, Judge.
And Your Honor, if the GPS could be at $1 a day if he does make bond?
Yes. And the GPS, you need to put on the GPS has to be affixed before he was released.
Yes, Your Honor.
Okay, thank you.
And he already has another court date for December 28th, Your Honor, so.
Okay.
And Your Honor, that concludes my business this morning, if I could be excused. Thank you.
Ammerman, David Ammerman.
I believe he's still at Florida State Hospital. Casey Etheridge for David Ammerman. Okay, we're here in 2019 CF 198. And Your Honor, we have not yet received an updated report in this. So, I mean, I don't know if the court wants to.
Have you tried, I mean,
I called them and I've left some messages, but we haven't received anything yet.
so let's come back maybe in a month.
Sure, it's fine.
December 1st?
For status.
Thank you.
Richards, Andrew Richards.
Good morning, Your Honor.
Good morning.
Tim Gibbs on behalf of Andrew Richards in 21 CF 1207, 22 CF 138, if I can have just one moment. Your Honor, we're requesting a continuance to 12-1 without subpoenas.
Very good. We'll continue to 12-1, 9 a.m.
Thank you.
Georgia Seiler.
Hold on. Tim Gibbs on behalf of Georgia Seiler in 21 CF 1191, if I may approach with a written plea and a score sheet.
You may. Thank you.
No objection to the score sheet on that, Your Honor. As you'll see the terms of the agreement on her violation of probation this morning, she would admit her violation, she'd be reinstated to probation, but it would be modified so that the remainder of her supervision term would be on community control, adding in the statutory costs that are associated.
That's the agreement.
Very good. Ms. Seiler, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Heard your attorney, you can put your hand down. You heard your attorney state the terms of the plea agreement, and I see that's the same thing as in writing, and you have signed this.
Yes, sir.
Have you gone over with your attorney, make sure you understand all the, what all this means to you legally?
Yes, sir.
And you're entering this freely and voluntarily?
Yes, sir.
You're waiving the right to go to a trial. This will be a final adjudication of this violation. Do you understand that?
Yes, sir.
And this will be original terms and conditions, is the time length, but you're now going to a community control. That's house arrest. Do you understand that? Are you willing to do that? A lot of supervision,
Yes, sir.
okay? You know what the next step is? There's probation, community control.
Prison. Yes, sir.
Don't want to go here.
No.
You got to stay in contact and do this right, okay? You have any questions concerning this? Okay, based upon that testimony, the court will accept your plea. We'll reinstate supervision on the original terms and condition, except it'll modify that the remainder of the supervision will be on community control. The fees and costs will be added, complete the original requirements. Okay, good luck, man.
Thank you, Your Honor.
We've been asked to go a little bit, number 47 on the docket is Marquise Cox, has Olivia Ramsey as the, but for some reason they got him in a different queue and he's waiting to come up. Can we do that one now? Do you know who's handling that, Mr. Gibbs?
That's Ms. Etheridge, I believe.
If you can go get her, that,
He's set for a competency this morning.
I've got listed as a status conference, but you're probably right.
She may be prepared to.
You bringing up Marquise?
Judge, while we're waiting, I can bring up one. We have a Paul Aurora that was added to the docket. Mr. Gibbs can stand in. This defendant is deceased. She does have a pending violation of probation before the court. The state would just ask the court to dismiss and revoke.
Do you have the case number?
Do, Judge. It is 19 CF 1133.
You get that, Madam Clerk? Okay, the court will dismiss.
Thank you.
Sorry, we got it out of order at the
On your-
inmate, so, sorry.
Casey Etheridge for Marquise Cox. And your, Mr. Cox is back from Florida State Hospital, and so, where he has been found competent to proceed. We're just asking the court make a judicial determination, and then Mr. Cox will be entering a plea to resolve his cases today.
That's correct, Your Honor. If you could find him competent to proceed, I do believe he wishes to resolve his cases today.
Good. Based upon the report from the hospital, the court will adjudicate him competent to proceed.
Okay. And Mr. Cox would like to admit to the allegations in the affidavit of his violation of probation case, and it would be for adjudication of guilt, revoke and terminate credit for time served, $50 cost of prosecution, $100 in public defender fees, and on 2021 CF 2085, he'd be entering a plea of no contest to adjudication withheld, credit for time served, $415 in court costs, $100 cost of prosecution, $100 in public defender fees, no contact with Donna Withers, and restitution to Donna Withers in the amount of $250. All fees, fines, and court costs will be reduced to judgment.
What about the cost of restitution? That would go to a judgment as well?
Yes.
Okay. State's in agreement?
That's correct, Your Honor.
And Your Honor,
Cox.
oh, sorry.
I'm sorry.
And I have for the record, Your Honor, I went to see Mr. Cox at the jail, and we talked about the cases, and I asked him some questions regarding competency, just to make sure that he does understand what he's doing. And so if the court wants to inquire, I just wanted to let the court know I did as well.
Thank you. So, Mr. Cox, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God? Okay, so, Mr. Cox, just want to make sure that you understand what this plea agreement is all about.
Yes,
Have you gone over this with your attorney,
yes,
and you feel like you understand what it is?
yes,
And importantly, this agreement is for revoke probation, and you'll get credit for time served, which means you'll be able to be released immediately. One of the important things is that you can have no contact with Donna Withers in one of your cases. Do you understand that?
yes,
Even if you run into her in public, you got to stay away from her, okay? Do you understand that?
yes,
Okay. And you feel like you've had all your questions answered from your attorney?
yes,
She came over to visit you over in the jail and go over this with you?
yes,
Okay. Do you have any questions of the court here today?
no,
Okay. Based upon that testimony, the court will accept your plea. On both of these cases, there'll be an adjudication of guilt. In 2021 CF 2085, there'll be an adjudication withheld. Both the counts will be credit for time served. 1401, revoked termination, fees and costs to collections. Okay. Thank you very much. Okay. Solis, thank you, Ms. Ether. Sorry to kind of get you out
No problem. Thank you.
of order.
Your Honor, Tim Gibbs on behalf of Mr. Roberto Solis, 17 CF 329, and if I could have just one moment. This again is the same here, it's 72 months.
What are we gonna do about it? Do I get you credit?
Yeah, they're stipulating this is your whole credit.
Okay.
Yeah. Yeah, sorry, today's date, we'll have to see they got shot white at least.
Yeah. This is for life. It's a third.
Second, yeah. Thank you. If I may approach, Your Honor, with a written plea and a score sheet. There is no objection to this.
Very good, thank you.
Your Honor, Mr. Solis is entering an admission of his violation of probation this morning in this case. The terms of the sentence would be that his probation is revoked and terminated. He'd be sentenced to 72 months in the Department of Corrections. However, there's a stipulation with the state that he be awarded 60 months' worth of credit total, whether that be prior prison credit or jail credit. So it is effectively 12 months DOC from today.
That's correct, Judge. He has 5 years credit time served, 60 months.
Very good. Mr. Solis, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, I do.
So you heard your attorney state the terms of the plea agreement,
Yes, sir.
and I see the same written plea agreement is contained in writing, and you've signed that. Have you
sir.
gone over this with your attorney, make sure you understand it? And you understand there'll be a final resolution of your case? And you're waiving the right to go to a trial and waiving some other important legal rights. Have you kind of gone over all that and made sure you had all your legal questions answered?
Yes, sir.
You understand that this is a final adjudication of this case? And are you satisfied with the legal representation you've received?
Yes, sir, I am.
And are you entering into this freely and voluntarily?
That's right.
Very good. Based upon that testimony, the court will accept this plea agreement. Court will revoke and terminate. Is this revoke and terminate probation?
Yes.
And sentence you to 72 months in the Department of Corrections with a stipulated 60-month credit for time served. Okay. There's a few costs and fees that are, I assume they'll go to collections?
Yes, Your Honor.
Okay. Very good. Any questions, sir? Okay. Thank you.
Thank you. Thank you, sir.
Gregory Spears.
Your Honor, Tim Gibbs on behalf of Gregory Spears, 12 CF 1016, 12 CF 1224. If I may have just a moment. Your Honor, at this time, we'd request to set this on December 1st without subpoenas.
Very good. We'll continue this till December 1st at 9 a.m.
Thank you, Your Honor.
Otis Terry.
Your Honor, Tim Gibbs on behalf of Otis Terry, 01 CF 1929, 21 CF 1613. If we can actually approach on this one briefly.
We're going to continue this case until docket day, which is this coming Monday, November 7th.
Thank you, Your Honor.
James Thomas.
Your Honor, Tim Gibbs on behalf of James Thomas in 19 CF 1448 and 21 CF 1143. Your Honor, we'd like to set this on December 1st without subpoenas.
No objection.
Very good. December 1st, 9 a.m.
Yeah, we'll do that. We'll do that in December if we have.
Jarvelis Thomas.
Your Honor, Tim Gibbs on behalf of Jarvelis Thomas, 19 CF 2582, 19 CF 2598, 19 CF 2663. Your Honor, we'd like to set Mr. Thomas on December 1st as well with subpoenas. We've been having some issues getting some responses from Keaton House. We've referred him there. We're trying to get that response, whether or not he's accepted into Keaton, so we can get him over there for treatment.
Very good. So we'll continue until December 1st.
Thank you.
Without subpoenas. Ronald Way.
I'm sorry. Yeah, you're good. Your Honor, Tim Gibbs on behalf of Ronald Way, 21 CF 3143, 21 CF 16, 21 CF 2965. On one of these cases, Your Honor, on 20 CF 3143, I just wanted to kind of point out for the court's attention, and I can file any motion that might be appropriate. That's a fugitive from justice charge. When he originally pled to these cases on January of this year, the plea agreement only included the two newer cases, 21 CF 16, 21 CF 2965. Both of those included failure to register charges. 20 CF of 3143 was a fugitive from justice. The plea agreement only included the two failure to register cases. My understanding is that because he had gone to Mississippi where the out-of-state warrant was, resolved the case there, and had come back, turned himself back in after resolving Mississippi, believed the fugitive from justice case should have been dismissed. It was not included on the plea agreement. However, on the minute sheet, the fugitive from justice case was included as being sentenced to the probation and 5-year suspended sentence. So I believe that case should not be included. That case should have been dismissed.
And Your Honor, that was our intent, to proceed on the failure to registers and dismiss the fugitive at that point. It was our understanding that Mississippi, I believe, was not planning on extraditing him at the time. So our intent was only to proceed on the failure to registers and not the fugitive from justice.
So technically, as we sit here today, if it wasn't dismissed, it was the intention of the state to dismiss, and we'll announce dismissal of the out-of-state fugitive from justice?
That is accurate, Your Honor.
Okay. Court so orders.
Thank you, Your Honor. I just wanted to make sure that was very clear on the record.
That's good. That's good.
Otherwise, Your Honor, we are looking in.
Okay.
Thank you.
Go ahead.
Otherwise, Your Honor, we are looking in how to resolve the VOPs this morning, so we'd like to put this on December 1st without subpoenas.
Very good.
To try to get that resolution.
We'll continue to December 1st at 9 a.m. Rochelle Wilson.
Your Honor, Tim Gibbs on behalf of Rochelle Wilson, 21 CF 3276. We'd like to continue this, Your Honor, to December 1st without subpoenas so that Ms. Wilson and I can have a meeting together, have an appointment together.
Okay. Very good. Continue to December 1st without subpoenas. Cody Womack.
Yeah, no. Get it in the meantime. Your Honor, this is Mr. Cody Womack. Tim Gibbs on his behalf in 21 CF 1300. If I may approach with a written plea and a score sheet.
Thank you.
No objection to the score sheet, Your Honor.
Okay, thank you.
Your Honor, as the written plea agreement reflects, Mr. Womack's going to enter an admission to the violation of probation in this case. He would be restored to probation, however, it would be modified to extend for 1 year beyond his current termination date, which I believe is coming up in January. He would have to, of course, complete the original requirements, and he would need the additional condition being the new cost, as well as to complete a substance abuse evaluation and treatment if recommended at Bridgeway, with the first session having to be within 30 days of his release from jail.
Should we say the first session or the evaluation?
Oh, we can do the first.
I'm asking probate. That's all right.
Oh, I'm sorry.
The question is, we just want to make sure that we can he can fulfill what we're asking him. That was my question.
Your Honor, we
Might be
can't
worded
ensure
different.
that that's going to happen.
Right.
We can ensure that within the first 30 days, we'll refer him down there, but we can't tell you when they will be able to see him.
Yeah. Okay. So what we'll say, the first shall happen, when we just say he will be referred in the 30 days. Is that okay for the state?
Yes, Judge.
Okay. So with that change, I'm going to ask you to change this just a little bit.
Yes, sir.
Would you come up and?
Thank you, Your Honor.
I just need to ask you a couple questions just to make sure.
Yes, sir.
That this is free and voluntary, you understand it. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement.
Yes, sir.
We're extending probation a year. Got to go down and get an evaluation within 30 days, or at least it'll be referred. Sometimes it takes a little time with Bridgeway, but as soon as you can get that in, obviously that's one of the most important things. If, you know,
Yes, sir.
we talk about trying to be successful in these probations.
Yes, sir.
You're not going to be successful if you fall off the wagon.
Yes, sir. Y'all ain't the only one. I got a 8-month pregnant old lady that's gonna kick my butt too. So.
Better stop calling her old lady and like your butt anyway.
Too, no doubt.
So, no, I understand. I mean, we got motivations, and that is a good motivation.
Yes, sir.
And if you can't do it with that motivation, but you have to look, you got to look that horse in the face to face. That's tough.
Yes, sir. Yes, sir.
Addiction is a
It's
tough
gonna be a
thing, so
fight,
you
for
got to
sure.
you got to fight it.
Yes, sir.
But you got an opportunity to do that, and this will be an additional incentive.
Yes, sir.
Okay?
Yes,
So
sir.
you understand that by doing this, you're waiving the right to go to a trial to contest
Yes, sir.
this. This will be a final resolution of this violation. If you had all your legal questions answered,
Yes, sir.
and you feel this is in your best interest to enter into this plea agreement.
Absolutely.
Very good. Based upon that testimony, the court will accept the plea agreement, restore probation, modify it to extend it 1 year. Additional fees and costs, you must complete the substance abuse and whatever recommendation at Bridgeway, it'll be referred within 30 days. So
Yes,
you
sir.
need to be on top of that.
Yes, sir.
Okay, very good.
Thank you, Your Honor.
Thank you very much.
Yeah, your fingerprint, you'll meet with probation.
Richard Byrd. I've got Mr. Medina being the public defender on that. I don't know, I want to make sure that was properly referred up here. I assume
Your
it's
Honor,
from the south end.
We do not understand why it was referred up here. It was a South End case. We have nothing but a notice from the clerk.
Can you help us at all?
Richard Stephen Byrd. It's POP.
For the morning.
Oh, yeah. Yeah.
1, 2, 3, 4, 5, 6 for the other one, 7 for the other one.
Okay, well, if it's closed according to benchmark, then we're gonna
Close it out.
take that. Okay. Now, we don't have to do anything further with Stephen Creech, because we've got that was previously dealt with.
Yes, Your
correct?
Honor.
So Samuel Langley, Mr. Russell, we're onto your cases now.
Yes, sir. Charles Russell, Public Defender's Office, Judges is Samuel Langley. Case number is 21 CF 348. This time, we're asking to pass the case to 12-1 without subpoenas. Mr. Langley wants me to look into some credit issues on his case.
Very good. Continue to December 1 without subpoenas. Diara Lewis.
That's okay. Charles Russell, Public Defender's Office, Judges is Diara Lewis. Case number is 21 CF 1685, 21 CF 1697, and 21 CF 2446. They're all VOPs at this time. We're asking to continue all three to 12-1 at 9 to see if there's some kind of settlement we can work on.
Continue to December 1 at 9 a.m. without subpoenas. William Littleton.
Judge, if I could have a moment.
You may.
Judge, Mr. Littleton is here on case numbers 20 CF 1998 and 22 CF 860. Mr. Littleton is asking that both of his cases be set for a contested evidentiary hearing.
Very good. Madam Clerk, what's our next? December 1, what do we look like in the afternoon? Okay. Why don't we do it on December 1st, 2 p.m.?
Thank you, Judge.
Thank you. Sherry Lucky.
Charles Russell, Public Defender's Office. This is Ms. Lucky. Case number is 22 CF 2503. We are here this morning on a bond reduction hearing. She is also on this afternoon's docket. If you'll look on page 3, she's number 10. That's for a felony plea day. We can go ahead and take care of that this morning, too.
Okay.
On the felony plea day, we'll plead not guilty, request trial by jury, and 15 days of filing pre-arraignment motions, and set her for 12/28.
Correct.
And then on her bond hearing, Judge, I said in my bond motion that her current bail is $3,500. Actually, it's $3,500 on the DUI, and then it's $1,000 cash or professional on the DW driving while license suspended, with pretrial services, a scram before release, and no drugs or controlled substances. She is asking for an ROR, or signature bond. She's been in custody since September 21st, 2022. She has a job waiting for her if she gets out. She's lived in this area for 15 years and would reside at 7.
So what's her current bond?
$3,500 cash or professional with some other conditions. I mean, $4,500 cash or professional, I'm sorry.
Sorry, 45?
Yes, sir. $1,000 on the driving while license suspended, which is count 2, and DUI, which is count 1, is $3,500. So it's a total of $4,500 cash or professional.
And are there conditions on the DUI?
Yes, sir. Pretrial services, scram monitor before she's released, and no drugs or controlled substances.
Judge, the state's requesting that the bonds remain as they are. State feels that the $4,500 that's imposed at this time is very, very lenient considering the facts of this case and her history. In this case, Judge, she crashed while she was driving on an indefinite driver's license suspension due to DUIs in the past. She had a blood alcohol level of 0.30. In 2018, she was arrested and was convicted of driving under the influence as well. And at the hospital in that case, 12 hours after the crash, which she crashed in 2018 as well, she had a blood alcohol level of 0.286. And in 2012, she also crashed while she was drinking and driving. She was convicted of DUI and leaving the scene of an accident. In that case, she crashed on Highway 98, and she blew her blood alcohol level was a 0.151. So in 2012, 151. In 2018, she's got a 0.286, and now she's up to a 0.30. She drinks, she drives, she crashes. The state feels that she is, in fact, a danger to this community. The state's concerned for the safety of the other drivers on the road. I don't know of any conditions we can impose to prevent her from driving. She already has an indefinite driver's license suspension, so the state feels concerned that she is a danger to the community. And given the fact that $3,500 for her third DUI with such a high blood alcohol level and a crash and $1,000 for driving on an indefinite suspension is more than reasonable.
So, Ms. Lucky, I don't normally say this when I have these bond hearings. I'm surprised it's as low as it is. Quite frankly. The court's denying the motion to reduce bond. You're gonna, if you don't get this squared away, maybe you're gonna kill somebody. You're gonna end up in jail for the rest of your life. But we're dealing with this now, and that's what we're dealing with. Court will deny. Joshua McKenzie. McKenzie.
Charles Russell, Public Defender's Office. Judge, this is Mr. McKenzie. Case number is 20 CF 2881. The state and I have reached an agreement, but we're going to ask to postpone the case to December the 1st at 9 without subpoenas, and we'll be able to settle the case on that day.
Very good. Continue to December 1 without subpoenas at 9 a.m. Janice Martinez.
She's not in custody. She's out. Charles Russell, Public Defender's Office. I think it's Janellis Martinez. Anyway.
Janellis, okay. Sorry.
I think. 18 CF 3100. We filed a waiver on behalf of Ms. Martinez. She lives down in Sarasota County, quite a ways away. We filed a waiver for her appearance because we were just going to ask for a continuance to 12/1 anyway today.
Has there been a denial already entered?
I believe so. I think we've already had like an arraignment on it.
We need to continue until when? December 1. Continue without subpoenas to December 1 in the a.m.
Correct, Judge.
Zachary McKinney.
Charles Russell, Public Defender's Office. Mr. McKinney's case number is 20 CF 555. On Mr. McKinney's case, Judge, we're going to ask for a continuance to 12/1 at 9 o'clock without subpoenas. We are in negotiations with the state. I wanted some time to check into something, see if we can work something out.
We'll continue till December 1 in the a.m., 9 a.m. without subpoenas. Logan Miter.
Charles Russell, Public Defender's Office. I believe he pronounces his last name Mitri, Judge. So Logan Mitri, case number is 20 CF 478. And on Mr. Mitri's case, we've reached an agreement. It is a violation of probation. In exchange for an admission on the violation of probation, he's going to be adjudicated guilty, revoke and terminate the probation, be sentenced to 180 days in the county jail with credit for any time served. He would pay a $100 cost of prosecution, $150 public defender fee, and $100 in court costs, and he would get 180 days after his release to pay, or the money would go to collections.
That's the agreement.
Is it Mitra?
Mitri.
Mitri?
Yes, sir.
Mitri. Mr. Mitri, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
And Mr. Russell, it's a score sheet, okay?
Yes, sir.
Okay, Mr. Mitri, you heard your attorney state the terms of the plea agreement.
Yes, sir.
And I see that that's saying those same terms are contained in the written plea agreement, which you have signed. So is that your understanding? Did he recite that properly? Is that your understanding, and are you in agreement on this?
Yes, sir.
You understand that by entering into this plea agreement, you're waiving some valuable legal rights. The most important of which, to go to trial, to contest this, force the state to prove their case beyond every reasonable doubt. Well, this is a VOP would be a greater weight of the evidence, but still they have to prove their case. You're waiving all that, and this will be a final adjudication.
Yes, sir.
You understand that? If you had all your legal questions answered about this, what it means?
Yes, sir.
And are you entering into this freely and voluntarily?
Yes.
Very good. Based upon that, the court will accept this plea agreement, will adjudicate you guilty. The probation will be revoked and terminated. You'll receive a sentence of 180 days in the county jail, credit for all time served, $100 cost of prosecution, $150 PD fee, 180 days to pay that after your release, and then it'll go to collections. Court costs as well. Question?
Sir.
Okay. Thank you very much. Ollie Nelson.
Charles Russell, Public Defender's Office. Ms. Nelson is present and approaching. Case numbers are 21 CF 386 and 21 CF 1726. At this time, Judge, we're going to ask for a continuance to December 1st at 9 a.m. without subpoenas. She's being evaluated for possible rehab programs. We're going to see if we can get that taken care of by the next court date.
Very good. Continue to December 1st without subpoenas at 9 a.m. Michael Poor.
Charles Russell, Public Defender's Office, case number is 20 CF 1775. Mr. Poor is scheduled for this morning for a Nelson hearing. He's also on the 2 o'clock docket for an evidentiary hearing. State and I have agreed to continue the hearing this afternoon till 12:01 at 2.
I think that continuance was already granted.
I didn't see an order. I know the state submitted a motion and an order.
Hold on a second.
That's what.
I have it that it's been continued, so if the order hasn't been signed, the court is granting the continuance to 12:01. What about, we need to conduct the Nelson hearing today?
No. You're helping.
Okay.
You're helping.
You want me to inquire? Because the first inquiry.
Please.
So, Mr. Poor, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
First question, I need to ask you some questions.
Yes, sir.
Do you understand that we're taking this motion, it's called a Nelson motion or Nelson hearing?
Yes, sir.
First question I need to ask you, are you wanting to discharge your attorney?
No, sir, I'm not. Not at this time. No, sir.
Okay. Very good.
Yes, sir.
That'll end the need for this hearing today. If at any point along the way you feel the need,
Yes, sir.
you can file the motion.
Yes, sir.
The court
Thank you.
will
Thank you very much, Charles.
deny the motion based upon the request to withdraw it by the defendant.
If I have something to see. What?
We've got one.
Call whenever you're ready.
Okay. Who is it? I'm sorry, I'm
Elizabeth Graham.
Graham.
Yes. She's number 31, Your Honor.
No. We're talking about this. Yeah, I don't know what, I filed a motion. I mean, I got a motion. On Mr. Poor, Mr. Russell, on the continuation till 12:01, is that in the morning or in the afternoon?
2 o'clock, I'm sorry.
2 o'clock, it's a
Yeah, it's a
contested.
contest. Oh,
Okay.
do we have room? I didn't ask.
Yes,
Okay. That's fine.
yes, there is. Okay. Do you know what number, what's the name again?
31 and 32 is
Okay.
Elizabeth Graham.
Correct. Elizabeth Graham. Bless you.
Casey Etheridge for Elizabeth Graham, and she would like to admit to the allegations in the affidavit and accept the state's offer. In both the cases, 2020 CF 2264 and 2022 CF 570 these are both violations of probation. And in 2020 CF 2264, it would be adjudication of guilt, revoke and terminate probation, 2 years of community control, the cost of supervision waived, same terms and conditions, an additional $100 cost of prosecution, an additional $150 in public defender fees. And then 2022 CF 570, it would be adjudication of guilt, revoke and terminate probation, 2 years of community control, cost supervision waived, same terms and conditions, an additional $100 cost of prosecution, an additional $100 in public defender fees. And that's concurrent with 2020 CF 2264. May I approach?
Yes, you may. Okay, Ms. Graham, would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Ms. Graham, you heard your attorney state the terms of your plea agreement.
Yes, sir.
And I see that those same terms are contained in the written plea agreement that your signature appears to be affixed to.
Yes, sir.
So have you gone over this plea agreement and all the legal ramifications with your attorney?
Yes, sir.
Okay. And you understand that by entering into this plea agreement, you're waiving some valuable legal rights. You've heard me talk about it all morning.
Sir.
Right to go to a trial, right to have the state prove their case, blah, blah, all that.
Yes, sir.
Okay, you got all your legal questions answered.
Yes, sir.
You understand that this is a final resolution of your case,
Yes, sir.
okay, of both of your cases. You understand this is a substantive question, so we're revoking and terminating probation on both of them, and there'll be 2 years of community control.
Yes, sir.
Okay, and you've heard me use the term house arrest this morning. And I use that. That's not the legal term of it, but that describes it better than community control. It's a much higher level of supervision, okay? It's designed to try to really, make sure that things are going well and are you willing to do this higher level of supervision, this house arrest? Okay. You understand, and you've heard me say this, probation, community control, prison's next. I don't want to go there.
No.
I'm sure you don't want to go there. But you got to pay attention to this. You got to stay in good contact with your probation officer, and you've got to follow up on the things you need to follow up with, and they'll walk you through them. They'll work with you.
Sir.
You willing to do that? Okay. Very good. Based upon that, in both cases, there'll be an adjudication of guilt, revoke and terminate probation, and sentence you to 2 years of community control. Same terms and conditions other than that, with the additional cost and fees that are payable during the term of this community control. Question? Okay, good luck. And the defense is okay with the, of course,
Yes, Your Honor, no objection.
did the state acknowledge their agreement with this plea?
Yes, Your Honor.
Thank you. I believe that does it for this morning. You got to? Well, if I'd have known it early, I'd have gotten you out of here.
My last name's Williams. I'm going to be at the end of everything anyway. Judge, I've got
What case are we on?
Zachary Jernigan. And then he's got 3 separate cases. I can read the, I do not have a docket with him on it, but he is here.
Hold on. No.
And I was handed the file this morning and kicked in the direction of the courthouse.
Yeah, it looks
You
like.
by any chance have a number for me? What page you're on?
Your Honor, the case numbers look like they're 2019.
I'm trying to find it on my docket.
It's the last one on the docket, number
It's
59.
the last one on the docket?
At least the one we have. Sorry, the last one we had.
Yeah.
Printed it
Those
yesterday.
were those, I don't have those on my docket.
And Your Honor,
Sure.
Well, Judge, I'm going to make it easy and just move to pass it. I've had the files for maybe 1 day.
Okay. What
They're arraignments. They're here for a.
It's an arraignment?
Well,
It's a
they're
VOP
violation
arraignment.
or probation arraignment.
A VOP.
They've not been set for an evidentiary.
Okay. So we'll go ahead and enter a denial here today, and we'll
Yes.
come back on December 1st.
Thank you, Judge. And then I have one other. I called her name earlier and she did not answer. Is there an Amy Harrell?
And was this an add-on for today again? This is
I
not
believe
on
so.
my docket
We ran
either.
yesterday, so I don't know.
You are,
Hey,
but you are also
it was
going to
set for
call.
today? Yes.
Emailed the secretary and told her to expect.
Your
it.
Honor, if I may, I believe what may have happened is
Thank
because
you.
we're transitioning some cases from me, and it'll happen with Mr. Russell too, to Mr. Williams. And so I think it may have just been taken off because he filed.
I think these were
those
add-ons to the docket, because
Right.
that's what it says, and I
But
somehow.
they were set here originally, is what I'm saying.
They were originally set, though.
Oh,
This
really?
hearing was originally set for today.
Okay.
I'll just mark it as off docket on my file, Judge, and whenever we get a notice setting it someplace, I'll be here.
So, this is Amy Harrell. Has she been noticed?
State would, she was here last time, Your Honor, state would request capias.
Was she on the docket?
Yes.
She was on the docket and was here present according to the clerk's notes, and she was given notice of today's hearing. Court will issue an capias, no bond. Let's get her here and figure out what's going on.
All right, Judge.
We already did Zachary Jernigan.
We
What
did,
about
Judge.
Paul Aurora? Is that the
Your Honor, she's the one that's deceased.
Oh.
We dismissed that.
The only thing I have left is I've got an arraignment this afternoon on somebody, so I'll be back this afternoon then.
Okay, thank you, Mr. Williams.
Thank you, Judge.
Okay. Mr. Barry, you want your paper back?
I don't, but Ms. Galogly has advised me, I can't believe that you gave my only copy to the judge. I'm sorry.
I'll give it back. Okay, so does that do it for this morning?
Yes.
Okay, so we will reconvene. At least we have an hour. It's not full lunch break.